item number 64 in the supplementary list.
Hmm.
So if your lordship may be pleased to fix this matter at 2 o'clock in the afternoon, because I have already taken the consent from the other side. And
I'm
on
sorry.
27, your
I will
lordship-
finish up the order, the list. There are some oldest matters are of 24. I want to finish it off. Then I have 2 orders to dictate. So I can't guarantee.
Let it try maybe made.
Let it be there in the list. We'll
Yes.
see. Okay.
Because on 27, your lordship has passed an order that an attempt would be made to dispose it off.
Oh, if it does not reach, how will I? Because I have one order to pass. It will take some time.
So we'll
We'll
wait.
see.
We
You
will
take a
wait.
chance.
Yes, yes.
May I seek my lord's indulgence? My lords, may I seek your lordship's indulgence, my lords?
Yes.
I am SD Sanjay, Additional Solicitor General of India from Supreme Court. My lords, I have an item number 48. Item number 48, my lords, it's a contempt case. Yes, your lordships. Yes, yes, my lords. My lord, only my difficulty is, my lord, that presently I am appearing from USA. They have a different time zone. So if it could be taken up tomorrow as a within first 5 cases, my lord, because by the time it will be taken up, it will be 2 o'clock in the night, my lords.
No.
I am appearing for the petitioner.
Yeah, and this matter can be resolved, my lord. There is no contempt, in fact. This can be resolved. So once notice is issued to once notice is issued to Employees Provident Fund Organization, my lords, it can be resolved because, my lord, it is not a case, it's a case of pension, my lords, and the petitioner is getting the pension. It's getting double pension. Now he is only claiming arrears, my lord. That can be resolved by your lordships, my lord, by an order. So, my lord, if it can be taken up tomorrow within first 5
the
cases.
directions have not been complied with? There was a direction already that the areas have to be released. Why that areas were not released?
Yes, my lord. Now, because the petitioner is getting dual pension, one from Government of India and one from...
order? Have you passed any order to the effect that because of this thing, he is already getting his pension, so no areas...
My lords, that is an admitted position. Even the petitioner accepts that he is getting dual pension every month, my lord, double pension. Now, my lord, we have to recover certain amount from him. So therefore,
Sanjay, what happened is here, this is a contempt matter. There is a direction. Either you comply it in a manner known to law, or we'll have to get it complied with. I can't go behind the order.
I know, my lords.
So
I am conscious of that.
So that last line stands close, directing the respondents to take all effective steps to proceed for release of pension of the petitioner in terms of PPO number so-and-so issued to the petitioner. So if there are some areas under that PPO, you have to release it.
No, my lord, that's correct. The petitioner is getting pension. Now, my lord, the petitioner is getting the pension through the PPO from the Government of India, my lords, current pension. Now, petitioner is also getting, the petitioner is also getting pension, same amount from Employees Provident Fund Organization. Now, my lord, the problem is that we requested Employee Provident Fund Organization to discontinue the pension so that the amount which has been received by the petitioner can be deducted and recovered from the petitioner, and then the arrear can be calculated and given to him. Unfortunately, they say that under our rules, we can't stop it. Now, that is the difficulty. So what I submit...
Then this order wherein this has been dealt with by the coordinate bench, why you take it up on appeal?
Yes, we have taken it up on appeal. Appeal has already been preferred, my lords. But I wanted that this matter... Yes, my lord. It has not been listed for hearing. It has already been
Notices have been issued?
No, not yet, my lord. Now, appeal has been preferred, but notice has not yet been issued. So
is there a delay there? Is there a delay?
There is delay. We have filed a condonation application for that purpose because, my lord, this has to be sorted out. My lord, it is neither a case. It's not now it has not become adversarial litigation.
Give me a moment, Mr. Sanjay. Yes,
lordship.
My lord, that is exactly what I was about to submit, that they have preferred appeal on 4th of June. The matter, this contempt matter came up on 1st of June. Wherein
that is after 2 years.
After more than 2 years, 700 odd delays, and I have just got the details of the.
No, it is not maintainable.
It appeal.
Mr. Sanjay, when are you coming back?
Milords, I'm coming back after 22nd, Milords.
22nd.
Let us have it after 22nd.
We'll not trouble you when you are in USA.
Lordships.
You come back.
Lordships.
Can it be on 24th?
Uh,
25th?
yes, my lords.
24th?
Yes.
24th.
Lordships.
Heard Mr. D. Chakraborty, Learned Counsel for the petitioner. And Mr. You additional Solicitor General.
Lordships. I am Additional Solicitor General, Government of India, New
Also
Delhi,
heard
Supreme
Mr.
Court.
S.D. Sanjay, Learned Additional Solicitor General, appearing for the response. As prayed for by the Learned Additional Solicitor General, registry to list this matter again on 25/3/2026. You can come online, there is no issue.
My lord has fixed it on
My
20.
lords, then instead of 25, my lords, can it be posted in sometimes in July, my lords? Because by the time our my lord, appeal will also be taken up, and some it can be resolved somehow.
There is a latest decision of the Supreme Court that delayed appeal this contempt cannot wait for that outcome.
No, that's correct, my lord. So, my lord, here
Okay, we'll have it on 14th.
14th July.
14th.
Grateful, my lords.
14/7.
Enjoy your vacations.
Grateful, my lords.
Obliged.
May I please, Your Lordship?
Yes.
Item 42 on personal appearance was directed.
We'll take it up as the first item.
Lordship.
May I please, Your Lordship? My lord, I beg to mention item number 10, my lord. The petitioner side is also here, my lord. We need 3 weeks time, my lord. The case of the petitioner is under process, my lord. A certain period, he is continuing in service and getting salary. A certain period, my lord.
What is there? Nothing is there. 2 months he is on earn leave.
Yes, my lord.
Deduct it, rest. He came, you did not allow.
That is under process. I have received a letter.
But
yes,
this
my
is of sometime in 22, 4 years you are processing. The
My
leave
lord.
is of 22.
Yes, my lord. No, read petition.
22.
Yes, anyways, my lord, now it is under process. They have requested for 3 weeks time, probably, my lord.
As agreed to by the Learned Counsel for the parties, registry to list this matter again on 27/2026. Mr. Bora submits that D. Bora, Learned Standing Counsel, Health Department submits that the matter with regard to regularization of the period of service of the petitioner involved in the present petition is under process, and orders in this connection would be passed within 3 weeks from today. On the next date of listing, Mr. Bora shall place on record the orders passed in this connection by the respondent authorities.
My lord, my instruction doesn't say that within 3 weeks.
If you are processing, if you are not processing,
my lord.
we'll deal with the matter today itself. There is no issue.
Yes, my lord. Obliged, my lord.
5 years, 6 years for this small thing,
Yes, my lord.
making that man hang. He is not entitled, don't give him, but
Yes, my lord.
let him know.
Yes.
Yes.
Obliged, my lord.
Why are you here?
Lordship, I was not able to connect yesterday for the Wi-Fi.
We have
code.
asked you not to be here.
In
Which number? Item number
item
that,
number 5, with the consent of the other side, I beg to mention, item number 5.
You want to file an affidavit in opposition?
Affidavit in opposition, Lordship.
what affidavit you want to file?
Lordship, in this matter, it's a pension matter,
Huh.
Lordship. And then
He is entitled to a provisional pension.
regional pension is already
Getting. What happened to the criminal case?
It's already pending. DP is not concluded yet, Lordship.
DP show cause issued.
So cause
He
issue.
is not entitled to anything else.
Lordship.
We'll pass the orders today. Provisional pension, you give him. We have already did.
Provisional pension is already an interim.
Then what
by-
more can you get from here, Mr.?
My lord,
Subsistence allowance also.
area subsistence allowance
Huh.
is there, and
Yes, sir.
with regard to the regular pension, as to why they are denying
Because
me-
there is already a proceeding pending against you.
Yes.
but then my lord,
Because
should-
I have already passed an order in your case.
that is under appeal, my lord. It does not attain finality as on due.
No problem, no issue.
That is not attain
We will-
finality.
There is no stay on that.
No, there's no stay. But then, my lord, they'll have to file an affidavit stating as
I
to
don't
why.
think so. I don't think so. This is a case just pending here from last 3 years. There is a department proceeding instituted against you in 22.
22.
They have not completed it. That's another matter.
That's another matter.
But you have been sanctioned a provisional pension
That was
from the date
by
of
the
your
order of the court.
retirement.
By the order.
Secondly, you have also been given, you have not been given the subsistence allowance. That's your claim.
That is one of the
One.
prayers.
We will direct them to do that within a period of 1 month.
And with regard to the regular pension, as to why that has not been released.
This court, at least as far as this court is concerned, we have it on record 22 is there. We don't want an
22 is
instruction.
there when there's a charge sheet filed.
No, the show cause notice is a charge sheet. That institutes a proceeding under article, section rule
That
9.
charge sheet.
We'll see when the matter reaches. We'll be here for some time.
Okay.
Yes.
May it please the Lordship, I appear on behalf of the petitioner. I beg to mention item number 6. Can the matter be adjourned
Rejected.
for the day?
Prayer rejected.
May I
Yes.
please your lordship, with consent from the other side, I beg to mention item 13 and 14. As my learned senior counsel is out of station,
Who is appearing for the higher education? Let the matter be called up. I'll not pass any adverse order. Let the matter be called up.
okay, deeply obvious.
You are appearing for whom?
Lordship, I'm appearing for PD Nair, lordship.
College, university.
Yeah, yes, lordship.
Petitioner is, you make your submissions. PD Nair, if we required to hear him, we'll hear him.
May it please your Lordship.
Hmm.
Lordship, in item number 56, I'm appearing for the petitioner. Lordship, the respondents BTC have filed their affidavit, which was received by us only yesterday. Lordship, I'm seeking for a 2 weeks' time to file a reply.
56.
56, Lordship.
You are Mr. P. Das.
P. Das, Lordship.
Mr. P. Das, learned counsel for the petitioner, prays that he be granted further 3 weeks' time to file a rejoinder to the affidavit filed by the BTC respondents. Pray accepted. Registry to list this matter again after 3 weeks on a date to be fixed by.
I'm obliged.
Lordship, may I please to mention item number 43? I am here on behalf of the petitioner. I am supposed to file impleading petition as per last order. Yet I am yet to receive instructions regarding the name of the
A
neighboring.
prayer is made on behalf of Mr. N.K. Muri, learned counsel for the petitioner for an adjournment in the matter to facilitate filing of interlocutory application as undertaken in the matter. For filing of an interlocutory application for bringing on record the present incumbents. On the prayer of Mr. N.K. Muri, learned counsel for the prayer made on behalf of Mr. N.K. Muri, learned counsel for the petitioner. The matter stands adjourned for 4 weeks.
Lordship,
Registry to list this matter after 4 weeks on a date to be fixed by. Yeah. Yes.
Lordship, as per direction of the Honorable Court, Lordship, the petition contempt is before your Lordship. That what happened?
Madam, why these matters are pending from 2018?
Lordship, actually, that as per the order, Lordship, that we have to clear the 12 lakhs rupees to the petitioner, Lordship. But we have a budgetary constraint of only 4 lakhs only. And the next budget session, Lordship.
No, this
it will-
order was passed in 2018. Thereafter, around 8 budgets, I think, have been
Yes,
done.
Lordship.
Then
But recently, Lordship, we have also.
we are not concerned with the recent thing. We are concerned what you did from 2018.
Lordship,
Madam has something, get it.
it look. By the half.
The star mark.
Hmm.
Star mark, what we have done,
Yes.
it's given in the star.
Madam, don't strain yourself. We understand you're not keeping well.
Okay, sir.
What is the CF advance proposal?
Contingency fund, there's no budget, sir. No,
Contingency fund.
contingency fund.
NDC মানে কি?
Non-real certificate.
We'll get your secretary and your finance secretary here. Just pushing the file, ma'am. This is nothing other than just pushing the files. The orders of this court are not being even given its due respect. If you had any problem with this order, you could have filed an appeal, you could have filed a review. Now, ma'am, we will not bear this.
My lord, can I say?
Okay, what we do is,
in
you're not
July-
keeping well.
In July,
No,
have
we are not
corrected
keeping well.
budget.
I'll fix this matter in July. I'll fix this matter in July, get it resolved by July,
Yes.
or you, secretary, and the finance secretary be here and explain why it was not done. In terms of the directions passed by this court-wide order dated 3/6/2026, the Director of Secondary Education, Ms. M. Huzai,
Hujai.
Director of Secondary Education, is personally present. However, Ms. Huzai has expressed that she is not keeping well and accordingly is not in a position to make her submissions in the matter today. However, she has communicated that the order, violation of which is alleged in the present petition, is being processed for compliance by the respondent authorities, and necessary orders in this connection and the compliance of the directions would be made before the next date of listing. This court notices that the directions, violation of which are alleged in the present writ petition, was passed on 10/4/2018 and have remained unimplemented for the last more than 6 years. So accordingly, while dispensing with the further personal appearance of the Director of Secondary Education, this court directs that on the next date of listing, a compliance report be placed on record with regard to full compliance of the directions passed by this court, said order dated 10/4/2018. In the event the compliance report is not so filed, the Director, along with you have not even made in the
Yes, Lordship.
present incumbent party. The Director of Secondary Education and the Secretary in the Department of School Education, to whom the matter was so forwarded by the Director Secondary Education for compliance, shall personally appear before this court and explain as to why the orders passed have not been complied with. Registry to list this matter again on 30/7/2028. I'm
Lordship.
giving you enough time.
Yes, sir.
30/7/2027.
August.
August last part.
Budget.
August. Okay. 5th of August.
Lordship, last part of
5/8/2022.
August, because budget session is
Budget
from
not
July.
yet started,
Budget session is
not yet announced.
Okay. Then, madam, this order would be very strictly viewed.
Lordship.
26/8/2022. You take your time.
Lordship. Oblige you.
And madam, one request to you. Kindly tighten up your department. We are finding it very difficult to dispose of cases in absence of instructions coming from you. The councils just raise their hands. They are not in a position to place matters before us. And madam, one more thing, when you are here, this is just out of the way. A man comes before this court for provincialization of his services. We ask him file a review or file an appeal before SLC, that is you. And you come up with a plea that his name is not recommended by the DSC, so we cannot recommend it further. What is that, ma'am?
My lord,
What is that being? You, your secretary, all have been passing these orders. If the matter is genuine, his case has not been considered, place it before the DSC. How can you reject it by saying, no, your case is not recommended by the DSC, so we'll not consider your case? DSC is your creation, your body. If you find that the man is eligible, he has been considered on merit. If you find that he is not entitled, reject his case. But please don't reject cases that it is not recommended by the DSC. It's your body only, ma'am. Please look into that. Many cases would come down. Yes, ma'am. Thank you. Provincialized school?
Provincialized.
What is your right as a managing committee to insist that the school should be at place A or place B? Just for my information. What is your right?
Right.
That you're not a private school.
Not a
You're not a private school managing committee. You're not a venture school managing committee. You are a government school managing committee. How can you be over the government?
They have.
Why have you not dissolved these bodies, Mr. Naik?
Lordship, in fact, this place was selected by
Be
the
that as it may, where
local
is that
public-
right for them to select? Is there a scheme to that effect that the selection has to be made by the?
No, Lordship, in fact, construction committee went to the school
I'm not on that.
asking for location. Lordship.
What I'm on is the school is a government school.
Lordship.
The materials coming on record reveal that because the school is situated near River Brahmaputra, so there is a risk of erosion. Shore area, there is a risk of. So you wanted an alternative plot. Why you have not identified that plot, government land?
It's a government land, Lordship.
I know. Why the process of consultation? Where is the requirement?
The requirement is not there.
Then-
Local public is there. Local Gram Panchayat is there.
The Gram
Accordingly,
Panchayat have
the-
identified a post.
The MLA, local MLA consulted with the local people, Lordship.
And they have
Thereafter,
identified.
a place was identified. And Lordship,
Yes.
most importantly, Lordship, already 46%
Forget
construction.
that. We are not concerned with 46%. Yes.
Managing committee, sir, and the student, they are.
The public MLA, they say this
No, no.
land is identified.
Initially, public and school managing place selected one place. Subsequently, they absence.
But here also the material on the affidavit is that the place where it is now being constructed was selected by the school authorities, public and the MLA. And what right do you have? Which right of yours is violated? Just show me that.
Right is not there yet because
Withdraw this.
they are
Otherwise we'll impose heavy cost.
close it on the activity of us.
Huh?
On the basis of activity of us.
You pray, make a prayer. Mr. S. Islam, Learned Counsel for the petitioner, submits that in view of the contentions raised by the mission director, by the executive director, Samagra Siksha Ahom, in the affidavit filed in the present proceedings, and therein having contended that the work in question has already, the construction activity has progressed and around 46% of the work has been completed, as well as that the site at which the present school building is being so constructed was also selected, was also one of the plots selected by the school managing committee and the local public, Mr. Islam submits that he be permitted to withdraw the present writ petition. Also, prayer is not objected to by Mr. A. Naik, Learned Counsel for the respondents. Accordingly, the present writ petition stands dismissed on withdrawal. Find something problematic, come back. We are here.
Lordship, PNAC.
Or PNAC. Additional AG appearing for the respondent.
May agreement. On the last occasion, they come up with an instruction that is, they say that there is no feasibility report with respect to the
What is
object.
this feasibility report at the first place?
I have annexed the feasibility.
No,
report.
what is that feasibility report?
I do not know where from it has come.
I have not understood that. That's
But
why I'm asking.
I have annexed
What is there? Where is it?
page 61 of my petition. May I read, madam? The subject above and also the office earlier letter dated so and so. I have the honor to inform you that the schools mentioned in your letter under reference above were found to be feasible before 1/1/2006.
No, this feasibility is in respect of the school or the subject.
It says, the instruction said in respect of the subject. Now the next page 62 is in respect of the schools where I work.
That school has been provincialized.
Yes.
Huh.
And number 3, subject introduced, Nepali is included. So they have to come up with an
Yes,
answer.
madam.
Lordship.
The director was here. I forgot this matter. We could have asked her. Yes. What is this? Why? What has happened? Where is the provision for this feasibility report in the
Feasibility report.
2017 Act?
Lordship,
Okay, ma'am, you go through it, come back
Lordship.
after some time. Let her get herself
Lordship.
acquainted with the matter. You want to receive some instructions, receive. But I don't find all this please in your act.
Lordship.
What time?
Lordship, after,
Two?
Lordship two.
At 2. Apply. 2 first item, 215 first item.
Petitioner was working as instructor of school, my lord, and he was not promoted, although the juniors were promoted. My lord, only because of SCR was not easy, but SCR
He's
has been,
still in service?
my lord,
He's still in service?
I don't think, my lord, because they.
After service, how can we direct for promotion, Mr.
The provisional,
Amal Satpathy, Dr. Amal Satpathy, Supreme Court.
my lord,
After retirement, you cannot assume the charge of the post.
I cannot assume, my lord, the monthly benefit I can get.
That is, if you cannot assume, how will I give you that monthly benefit? Who is appearing for the respondents here?
The last time, my lord, they.
Mr. Soikia, you are appearing? Food and Civil Supplies?
Last time, my lord, somebody appeared and they paid for time.
Yes.
Item number two.
Two.
Yes, that's it. Purva is appearing, Lordship.
As Borua. As Borua.
Yes.
Oh,
Purva.
what happened? Where is the instructions? But your case, admittedly, your fundamental right was violated in non-consideration.
And SCR's, my lord, you just
No, all were there.
submitted, my lord.
You have brought it on record. I've
yes.
seen it.
18. It was 18, my lord.
Mr. Sahiwala, can you just wait for 2 minutes?
Yes.
Can you get that the
Yes,
comment?
sure, sure.
Yes.
My lord,
Have you? Yes, Mr. Musahari. Other than adjournment, anything?
Lordship, our affidavit has already been filed.
Ah.
Despite Lordship last order, as per kindly perused last order, Lordship.
You were given time in terms of the order passed in 8-1. 8-1-26, some directions were given.
Some direction was. Our authority for some.
Okay, how much time you want? 25,000.
After 2 weeks.
25,000.
All recorded.
25,000.
Lordship,
Okay.
our affidavit. Lordship,
25,000. We will not get this matters adjourned at your whims and caprices.
Lordship,
You took an adjournment on 8-1. You took an adjournment on 10-2. Now, for the last 6 months, you have not been able to get your instructions. Forget it, 25,000.
Lordship,
We will adjourn. This files, what do you think? We are just sitting here, wasting our time.
our affidavit available, Lordship. Our as per
You don't want to take adjournment.
Yes, Lordship.
Argue.
No, that they were fixed, they were appointed on the fixed pay, my lord. And then, my lord, your lordship will come to has the similar order, my lord, annexure, my lord, has A1, my lord, is type copy, my lord. That is, my lord, page 13. Page 13, eh? As per
13. Page
13, 1-3. As per education policy of BSc and instruction thereof.
That we have seen.
The only thing is that they were appointed, my lord, on a fixed pay, my lord. Contract basis. That until and unless, my lord, they were terminated, they are continued. They are not the civil servant, my lord, they are just contract. My lord, let them, if not necessary, let them terminate and, my lord.
They have already terminated you.
Has to pay.
They have already terminated you on 12-11.
No. That was
Similarly situated persons have come.
Similarly situated person, they were appointed, my lord. They were appointed by the individual order. They has to be terminated by the individual order. That was sought for by the earlier occasion the court, my lord, that whether the termination order, if any, directed to produce before the court, that on that count, my lord, they have taken time. That could not. Only thing, if not necessary, my lord, they are terminated.
To page 61. The same very plea was considered by a coordinate bench. at this court, and the court had rejected.
Regarding not the regarding
It's
fixed
binding
pay, my
on-
lord.
It's binding on me.
Not regarding fixed pay, my lord.
Yes. Same.
Well, until termination, my lord, they has to pay. Till termination, they
They
have
have
to pay.
said on affidavit.
Because
Have you filed a
we
rejoinder?
have no prayer for regulation.
Oh,
Affidavit
have you
says that-
filed a rejoinder to this affidavit? No.
Rejoinder not.
My lord, not necessary, because they are saying, my lord, in that case, what they cited, my lord, they are praying for regulation. I have no prayer for regulation, your lordship.
No,
I can-
either way also. You are praying for salary.
Only.
Till 2004, if you have not been paid any salary, we will direct them to consider and pay that salary.
My
That's all. After 2004, you're not entitled. But Mr. C. Goswami, now you understood?
Yes, Lordship.
Every case you did not take a adjournment.
Yes, Lordship. Yes.
But Mr. C. Goswami,
Well,
learned counsel for the petitioner.
Finished, my lord.
Also, Mr. B.C. Musahari, learned standing counsel,
BTC Lord.
BTC appearing for the
That's
respondent
phone
number
number,
5 and 6. None has appeared for the respondent number 1, 2, and 3. So, Mr. P. Nagopati, additional AG appears for respondent number 2. 2.
That's phone number.
The petitioner in the present writ petition have projected that they were engaged on fixed pay basis during the period 1997 to 1998 as LDA as well as gardeners by the erstwhile BSc authorities. Also, the petitioners submit that although they have been appointed by issuing individual orders of appointment, albeit on fixed pay basis, their salaries have not been released to them. Also, accordingly, the present writ petition was instituted by the petitioners, praying for release of the current salary as well as arrears salary with effect from the date of their respective joining in their services. Mr. C. Goswami, learned counsel for the petitioner, submits that the petitioners were continuing in their services, and although it is projected by the respondent authorities in the affidavit filed by them in the present matter that the services of the petitioners were terminated, no such order of termination was served upon the petitioner at any point of time. Also, accordingly, he submits that a direction be issued to the respondent authorities to release to the petitioner their respective salaries in the fixed scale of pay with effect from the date of their. You have not got salaries from the date of appointment.
From date of appointment till.
You have not got till now. You want that.
Not at all.
From the date of appointment, that is, which was effected sometime in the year 1997-1998. Also, it is to be noted that also I've heard Mr. B.C. Musahari, learned counsel for the respondent, BTC, submits that the services of the petitioners and other similarly situated persons were terminated by an order dated 12/11/2004 issued by the Joint Secretary BTC in terms of the resolutions adopted in this connection by the Executive Council of the BTC on 12/10/2004. It is submitted that the petitioners herein were all appointed without following any due procedure and were engaged without following any due procedure and were appointed against non-sanctioned and or non-existent posts. He further submits that the engagement of the petitioners did not have the approval of the BSc/BTC authorities. Also, Mr. Musahari has referred to a decision rendered by a coordinate bench of this court-wide order dated 31/5/2023 in WPC number 7878/2017, wherein under similar circumstances, this court had had rejected the claim of the petitioners therein for payment of their salaries. So accordingly, he submits that the claim made by the petitioners in the present petition would not be maintainable. I've heard the learned counsel for the parties and also perused the materials available on record. Also, the petitioners were appointed during the period 1937 to 1998 as LDA and as well as gardeners. The orders of appointment of the petitioners on fixed pay basis is seen to have been issued by the jurisdictional inspector of schools. However, such appointment is found to have been so affected, has been found to have been not affected against any sanctioned vacant post. Also, the petitioners, although contend that they have joined their respective service after the issuance of their respective appointment orders, which were so issued during the period 1997 to 98 and were not being authorized their salaries, the petitioners had waited for around
Earlier approach, my lord, earlier approach, my lord, page 34, my lord, judgment, they directed to consider by this court.
Same writ petitioners. How will we know?
That and others, my lord, Lokhiram Bosumotari, that is the one of the petitioner, my lord. That is the Lokhiram
approached this court during had approached this court in the year 2003 by way of instituting WPC number 3460/2000.
Lokhiram Bosumotari petitioner
The
number
said
3.
petition was disposed of by a coordinate bench of this court wide ordered it 23/5/2003. Some of the petitioners, by directing the respondent authorities to examine the claim of the petitioners for release of their salaries and allowances, It is submitted that in spite of the said directions, the respondent authorities have not released to the petitioners their salaries. Also, the petitioners is found to have waited for a further 17 years to institute the present petition. Also, as projected by the respondents, the services of the petitioners were terminated by an order dated 12/11/2004. Also, the petitioners have not disputed the said position by way of filing a rejoinder. Further, the termination orders issued in respect of the petitioners have also not been challenged. Also, accordingly, this court the only plea taken by the learned counsel for the petitioner in this connection is to the effect that the orders issued towards terminating the services of the petitioners were never served upon them. Also, considering the matter, considering the attending facts and circumstances involved in the present petition, and the delay occasioning in approaching this court in the present round of litigation, this court is of the considered view that the termination of the petitioners would not be permissible to be now examined after such long delay. Accordingly, the petitioners are held to be not in service after 12/11/2004. Also, considering the contention of the petitioners that they have not been released their salaries since the date of their initial engagement, which was so affected by the Jurisdictional Inspector of Schools, BDC, Borpeta, in the year, during the period 1997 to 1998. This court directs the petitioners to submit individual representations before the Director of Education, Bodoland Territorial Council, staking their claim for being released their salaries in arrears with effect from the date of their initial engagement till 12/11/2004. The petitioners, for the purpose of justifying their presence in this said school, shall bring on record materials in support of the same. So, the Director of Secondary Education, Education from our Bodoland Territorial Council, on receipt of such representations from the petitioners, shall consider the same in accordance with law and pass orders thereon and communicate the same to the petitioners. In the event the petitioners are found entitled to receive the arrears salaries for the period of service rendered by them till 12/11/2004, the respondent authority, the Director of Education, BTC, shall release to the petitioners their respective wages, salaries, jotkushu wages, in terms of the order of appointment issued in their respective cases. With the above observations and directions, the present petition stands displayed. Mr. Musari, every case, please don't comment.
Even in this
You read
matter,
the brief, it is there.
even in this matter, Lordship, petitioner.
And 6
did not
months,
file their
it doesn't look
reply.
nice. It doesn't look nice. 6 months, no instruction. Next time you make this submission, I'll have the director here. It will take on temp. Yes, Bora.
Instruction received, Lordship. Petitioner got the relief, Lordship. He has promoted to the post of Superintendent Food and Civil Supply in the year 2020. Order has passed on 7/11/2020. And after
When did you
that,
retire?
retired on 31st October 2024, Lordship.
In fact, my lord, no communication, nothing, my lord.
31?
I'm sorry.
October
That was all listed after that, my lord.
After that, he was promoted also Assistant Directed Food and Civil Supplies.
Heard Mr. G. N. Sayavala, Learning Council for the petitioner. Also heard Ms. G. as
S.
Ms.
Borua.
S. Borua, Government Advocate, appearing for the respondents number 1 to 5. Ms. Borua, on instructions, has submitted that the FUSOP. In the present petition, the petitioner has prayed for a direction upon the respondent authorities for his promotion to the post of Superintendent Food and Civil Supplies with retrospective effect, that is, with effect from the date his juniors were so promoted. Ms. S. Borua, Learned Government Advocate, appearing for the respondents number 1 to 5, on instructions has submitted that the petitioner was promoted to the post of Superintendent vide an order dated 7/11/2020. It is further projected that the petitioner was thereafter promoted to the post of Assistant Director, FDP Roman and CA, vide an order dated 27/12/2023. It is also projected that the petitioner had thereafter superannuated from his, had retired from his services on reaching the age of superannuation with effect from 31/10/2024. The petitioner being found to have been granted his promotion to the rank of superintendent with effect from 7/11/2020, and also further promotion to the rank of assistant director, vide order notification dated 27/12/2023. The petitioner not having come up before this court assailing the said orders of promotion and praying that the same must be given retrospective effect. This court holds that the relief as sought for by the petitioner in the present writ petition has already been granted to him. So, in view of the above developments taking place in the matter, the present writ petition is held to have been rendered infructuous. Accordingly, the writ petition stands closed on being rendered infructuous. The instructions furnished by Ms. S. Borua is kept on record and marked as X for the purpose of identification.
Matter was also not listed, my lord. No,
It's okay, it happens. Happens.
Please, your lordship, we have
Done.
received. Yes, lordship, on 2nd of May, we'll receive the.
PPO issued.
Yeah, lordship, PPO is ready, lordship.
Done.
But gratuity has not sanctioned, my lord.
A GPO will also come.
Lordship, gratuity is not entitled because while forwarding the pension proposal, lordship, the department has stated that discharge is not admissible. Accordingly, we have this is.
Come up again. What is this?
He may file, lordship, another. He has completed 20 years of service, my lord.
Okay, you come up.
Yes.
The heard Mr. K.R. Padgiri, learned counsel for the petitioner. Also heard Mr. R.K. Talukdar, learned standing counsel AG, bracketed A.E. and Ms. M. Das, learned standing counsel PWD. So, Mr. R.K. Talukdar, learned counsel for the learned standing counsel, accountant general, bracketed A&E, bracket over Assam. On instructions has placed on record the FPPO dated
Lordship.
FPPO number 9123144. Yep, silent. This has not been issued.
Lordship, it is ready, lordship, for this.
Has submitted that FPPO number 91231441106 has been finalized, authorizing to the petitioner family pension in respect of the services rendered by her deceased husband, late Abdul Qadir. So he submits that the PPO would be issued to the Treasury officer with a copy to the petitioner shortly.
So within 2 or 3 days, lordship.
Within a week. So, Mr. K.R. Padgiri submits that the PPO having been finalized, and the same now being undertaken to be issued to the petitioner within 2 to 3 days, the grievance with regard to non-sanction of family pension to the petitioner has been redressed. Mr. Padgiri, however, submits that the petitioner has not been authorized a DCRG in the matter. And no GPO, gratuity, no GPO has been issued to the petitioner. He submits that the GPO has also not been issued to the first wife of the petitioner who had earlier submitted applications. So, he submits that the present writ petition be closed with liberty to the petitioner to approach the respondent authorities praying for grant of gratuity to the petitioner in respect of the services rendered by her husband. So, in view of the above developments taking place in the matter and considering the submissions made by the learned counsel for the parties, this court directs the Accountant General A&E to issue the FPPO noticed herein above, which is already finalized to the petitioner and other concerned authorities within a period of 1 week from today. Further, the court grants liberty to the petitioner to approach the departmental authorities, that is the authorities in the Public Works Department, praying for being authorized gratuity and other pensionary benefits as may be admissible for the services rendered by her husband. So, in the event of receipt of such application by the authorities in the PWD department, such the same be given its due consideration and disposed of by way of passing a speaking order within a period of 3 months from the date of receipt of such representation along with a certified copy of this order. With the above observations and directions, the present petition stands closed. A copy of the finalized FPPO produced furnished by Mr. R.K. Talukdar, Learned AG, a Learned Standing Counsel AG, bracketed A&E Assam, Accountant General Limited, is kept on record and marked as X for the purpose of identification. Take this back.
Oblige.
Where is my order?
That order I don't have right now.
You have a number?
I have the party name, Profullo Bora. I'll give that number to her. So
subsistence allowance will direct. Subsistence allowance for the period. Huh?
Lordship, we have already issued the authority of subsistence allowance before the treasury officer, Lordship.
Okay, subsistence allowance given.
Yes, Lordship. This is
copy assigned.
When is your period of suspension?
My lord, the prayer says with from 23 to 2022 to his date of superannuation, that is 31/12/2022. That is the prayer in page number 17.
Okay, where did you receive? You have not received any subsistence allowance during your period of suspension.
No, my lord. That is why the prayer number A, my lord, page 17, my lord.
You were prayed for 3 months till 22 to 2022.
23 to 2022 till his date of superannuation, 31/12/2022. Provisional pension, my lord.
You have not given him.
we have issued the authority pay slip, Lordship, to the treasury officer. Lordship. I've stated in the instruction it is stated.
Subsistence allowance is only for 3 months.
Yes, Lordship. Pay slip issued, Lordship.
Huh?
Pay slip issued, Lordship. Pay slip issued to the treasury officer.
A pay slip issued, but whether that will be enough?
Yes, Lordship. The treasury will make payment, Lordship.
Then why have you written that the DDO and the concern is liable to make payment on this tract? It is pertinent to mention here that subsistence allowance for the period up to the date could not be authorized for non-receipt of sanction order.
Lordship, for a period, Lordship, we have issued, but the subsequent amount with the sanction has not been received from the department, Lordship.
Then how complete relief he will not get.
Lordship, as per department's Lordship authority.
So you take steps, we will give you 1 month time. Within that, entire subsistence allowance with arrears has to be released. Continuous payment of provisional pension and nothing more, that's much.
That judgment, my lord, I have given. And only thing my submission would be whether this case also falls under that. No, because here whether the charge sheet has been filed or not.
Oh, charge sheet, Mr. Here the departmental proceeding is there, page 33.
Page 33, yes. Well, that's a show cause notice.
Show cause notice, that is the.
But pendency of the departmental proceeding cannot be a ground.
Show me.
Kindly come to my lord, page 48. In fact, I'll take your 48, it starts.
Or this we have distinguished already.
No, but this is distinguished in the case of a judicial proceeding.
Mr. You go to KV Radhanaki Raman.
Yes.
In case of seal cover procedure, it is set the date the memorandum of charge.
Memorandum
of charge under CCS rules, under the rules of the state, it is a show cause notice under 9.
Yes.
If it is a show cause notice under 9, a departmental proceeding stands initiated.
Yes.
Once it is initiated, 22 kicks in. That's it.
So in my lord, limited understanding, insofar this rules of 1964 is concerned, that proviso, that explanation to the proviso in rule 21, which has been stated in your lordship's case. There, my lord, it is only the charge sheet in the judicial proceeding, not in the departmental proceeding.
How it would be also. Pension.
Kindly see, my lord, that your lordship's order. In that case, my lord, there's a judicial charge sheet in the judicial proceeding.
Which is the provision you want to look into?
My lord, that explanation is there, my lord, to the proviso.
Explanation to the.
My lord, can I point out, my lord? Because they say they will take time, so I didn't bring my book, my lord.
This is the one. A departmental proceeding shall be deemed to be instituted on the date on which the statement of charges is issued to the petitioner pensioner, or if the officer has been placed under suspension from an earlier date on such date. Now, in your case, there are two circumstances covering. You being under suspension from that day,
yes,
it is deemed that you will be a proceeding is instituted against you.
Yes.
Right?
Yes.
And in your case, during that period of suspension, a show cause notice under 9 was given.
Yes.
So, in the view of the matter, this will be covered by that show cause.
Show cause is 12/1/2022. Now, my lord, my respectful submission before this honorable court would be merely because that judgment which your lordship has given,
You tell me.
Yes.
When is a departmental proceeding? When can a departmental proceeding be deemed to have been?
On the date of show cause. On the date of show cause. There is no, quarrel with the fact that there's a departmental proceeding pending. But the rules in 21, it never, my lord, precludes a person from regular pension merely because a departmental proceeding is pending.
No. That precluding will come in 22.
22 is for, or my lord, can we have a detailed, if your lordship has it tomorrow, I can, my lord, place everything. My lord.
You please come to 22, where any departmental or judicial proceeding instituted under Rule 21 or a departmental proceeding is continued under
The difficulty is, my lord, I did not bring the book because she wanted some accommodation in the morning.
But Mr. A.K. Burwa, Learned Counsel for the
Tomorrow,
at some length. Hearing remains. Also heard Ms. M. Kotofi, Learned Standing Counsel, Animal Husbandry and Veterinary. And Mr. R.K. Talukda, Learned Standing Counsel. For the Learned Standing Counsel, A.G. Assam and Mr. C.K.S. Burwa, Learned Government Advocate. Hearing remains inconclusive. Registry to list this matter again on Monday.
Obliged.
If you can't come, we have heard you, nothing more. This is the order. We'll just give Mr. Burwa a chance. If you're not here also, we'll record your name.
Obliged. Deeply obliged.
Get well soon, then come back.
May it please the Lordship. Lordship, can I humbly pray for some time being? My learned counsel is on legs in courtroom number 7 at the moment.
We'll have it at 12.
Deeply obliged, Lordship.
May it please the Lordship. These cases are covered by Sukendra Bachcharji.
But Mr. I Soikia, Learned Counsel for the petition, also heard Mr. P. Nayak, Learned.
Lordship, I have little objection, Lordship, because this issue is
I'm fixing it on 16th. You have an objection. We will hear it today only then. Serious objection of Mr. Oh, Mr. I'm not here to dispose of all matters.
Yes, Lordship.
That is what I wanted to do. Fix it on 16th.
Lord.
Now you have objection.
16th July, Lordship.
No, 16th of
this month. June. Why 16th, Lordship?
That is why the other matters are
okay, Lordship. In that group, yes, Lordship.
So you have objection, we will hear you today.
No, because this issue is pending before the division bench.
Which division bench?
I mean our division bench, Lordship. Family pension.
We have now Sudhanshu, Supreme Court judgment.
Sudhanshu is not in respect of works as employees, Lordship.
Yes.
So, no, Sudhanshu, Lordship, it has clearly mentioned that works as a distinct class, Lordship. That issue be decided by the government.
Was applied right and left by you in MR, work charge, casual, everywhere.
No, Lord.
Please don't take that plea. We have already passed orders, but here Mr. Gogoi in few matters wanted an adjournment on that day. So we fixed those matters on 16th. I wanted to take this up on 16th.
No, so far as Sudhanshu is concerned, we have other objections also, Lordship, that during hearing, Lordship, we will place that. But so far as works as is concerned, Lordship, it is my understanding, Lordship, that judgment said absolutely nothing so far as works as is concerned. That is
Para 96 and 97.
Lordship, it is said the works as being a distinct class.
No, why do you know why it was said? Why that was said? It was said because Upendas had a general effect.
That is a view
Then
of the Supreme Court.
Supreme Court said
Yes.
that is of no consequence. That earlier para 76 is enough. Supreme Court said that Upendas should not have been made applicable to the work charge people. They are a distinct class.
That is why, Lordship, workers were not everything.
Also,
That is
Mr.
what I'm
P.
saying.
Naik, learned additional AG appearing for the respondents along with Ms. M. Kotoki, Ms. D. Das Bormon, and Ms. R. M. Deka. All are appearing along with, and Ms. B. Chakra. And Ms. A. Sharma and Ms. M. Das for the Accountant General Assam. As agreed to by the Learned Council for the parties, registry to list this matter again on 16/6/2026. We are ready to hear.
Lordship will also consider the consequences also.
That we cannot.
Recently, Lordship must have gone through the judgment passed by the Allahabad High Court, Lordship. Very 2-3 days back. Wherein the Allahabad High Court has said that Lordship will see that order.
But here Upendas is gone.
Yes.
Upendas was the stumbling block. That is gone. Now everything open. Now you get that order modified, we'll have nothing to say. Otherwise, we are bound to follow that.
We'll place our arguments, Lordship.
I can't distinguish a Supreme Court judgment.
No question of distinguishing, Lordship.
And more so when that decision.
Lordship, just one line, Lordship, one line. Sukhendu is a judgment specifically directed the state government to give benefit to the appellants, not to others. In other cases, Lordship, it will be placed at best as a precedent. Lordship will consider that only. Lordship.
Naturally.
Whether this judgment
we are not saying that this order is being applied by Supreme Court to them. We will say
to the appellants. Direction was for the appellants.
In these cases, we will have to examine whether they are also similarly placed like that appellants and whether the decision of the Supreme Court 141 will be binding for us to apply on. Nothing more, nothing less. Interesting on 16th. Okay. Yeah. Amen? No. 8-9 to goal. 7-8 will go. 8-9 will go. Oh, 7-8 will go. No. Oh. Yes.
My lord, the petitioner required only thing is that when some documents is not supplied to him, so he cannot produce his audit reports. So last occasion we controvert, I filed an affidavit that how I approach. My lord, if that is given, my lord, then my pension is released. I have given then how and when
Yes, Ms. Musari.
Lordship, the latest instructions. Lordship, cooperation from the petitioner.
So affidavit is directed to file. We have filed affidavit. How we cooperate? They have not filed affidavit. I don't know. They also can.
Lordship, he is the IS, your Lordship.
Inspector of school.
Inspector
Okay,
of school.
madam.
Lordship.
What is this Inspector of Schools writing? Is he said to have an audit done? Is he responsible? Is he has to go to before the director of audit, come and do audit in my office? Or is it your requirement?
Lordship,
Who is this? Get him. Come, ask him to come online. We will deal with him.
Lordship.
What is this being done, miss?
Lordship, that is what I.
Moreover, as per rule, so and so, you are requested to apply for your audit at director as early as possible. Is it? Is that it?
Lordship, the audit report he has to.
Who has to? If the audit report is not there, not there.
It is the school authorities, Your
Then
Lordship.
why is it being directed to the petitioner?
School authorities, and it seems that they are not giving the.
Then release to his pension without anything. Give him everything.
Because he was the headmaster, Your Lordship. He retired as headmaster.
I know.
And
there may be some recoveries. If there is an audit
Lordship,
required,
Lordship.
that audit has to be done by the authorities, not by the employee. How can he go and ask? Who will give him any credence for that? You have a talk with this man. If this is the thing, we are drawing him here. If this is his understanding, he's not fit there. He's not fit. He's not fit. I'm sorry. We'll pass very strictures against this.
Then Lordship, let him be online. Let him explain because I have been.
Get him online immediately.
Lordship.
When he's ready, just tell me.
Lordship.
Eleven to 9 at home. 11. Yes.
Lordship, readings are complete in this matter.
Okay, readings are complete. Everything is complete. Why his dues are not being given?
Because Lordship, they have.
There may be delay. They are poor people.
Lordship.
But once they have come before you, you have not denied their right.
Yes, Your Lordship.
Then why the payments are not being made?
Because that needs to be calculated by the authorities, Your Lordship.
Whoever it is, calculate. You are the liquidator.
Lordship. Lordship.
How much time will you require to finalize this?
Lordship.
Get your instructions and tell me.
Lordship.
Within half an hour.
Lordship.
Please, Your Lordship.
Who is appearing for the respondents? This will be SSA.
Yes.
Who is appearing for SSA? Mr. Nayak is appearing. Just see whether he is around. Who appeared in the last date? Oh, this is only the returnable date.
Lordship.
Oh.
No affidavit filed. No affidavit filed.
What is your right?
Only right is Lordship regarding revised pay scale, Lordship.
Revised pay scale. What was the pay scale you were receiving when you came?
That document that I have not annexed, but Lordship, I have given a statement, Lordship, in my.
That is your statement.
Yes. Yeah, that statement is.
So when you came there, what salary you were receiving?
That salary statement was thereafter when I was absorbed from SSA to RMSA. Then it was specified that post was approved to the RMSA, and accordingly he will get the revised pay scale with effect from 1st of April.
Where is that?
Yes, Lord.
Page 29.
Lordship, P9 is in another court.
Page 29. Lordship. 20, 29, 27, 25 starting. Lordship.
This is the order.
Lordship.
Decision of the Executive Council.
Yes, Lordship. Will,
Where is there?
Lordship will find at page 32.
32.
Lordship.
Hmm.
Revision of pay in respect of SSA official attached to RMS.
So where is that revision? See, your absorption took place on which day?
It was in 11 also.
Huh?
It was in 11.
26/7/2012. And this revision is of 2013. How can it be made?
Effect from what you will see the effect. The third line of the content.
1/4.
1/4 of 12.
Okay. Where you given this effect? when you joined in the RMSA? Because your salaries were being paid by your parent organization.
Initially, I was in SSL Lordship. Subsequently, I was absorbed to RSA, permanently
No, no, no.
absorbed, Lordship.
You were sent to RSA
Lordship.
On 27/4/2012,
Lordship.
right?
No, Lordship, it was in 22/9/2011 first. That page, Lordship, 23.
Page 20.
3. In pursuant to the order number so and so, dated so and so, Assam, the following employee of SSA are allowed to work in the Assam, the office of RMSA on deputation with effect from date of joining with RMSA. Then Lordship.
May 2011.
Yes. There is also page 24 is the absorption of.
Now, during the period you were in RMSA, who was paying your salaries? SSA.
Initially, I was SSA Lordship, but when I absorbed in RMSA, I was paid RMSA.
But here, in when they absorbed you, the absorption was as of 26/7/2012. That time, whatever was there, they gave you. But subsequently, this was revised. But that revision was not used.
Since I was in the.
But Mr. J. Kolita, Learned Counsel for the petitioner. The Learned Counsel for the respondent pray that they be granted further 3 weeks' time to file an affidavit in the matter. Pray accepted. Registry to list this matter again after 3 weeks on a date to be fixed time. The Learned Counsel for the respondent shall ensure that the affidavits on behalf of the respondents represented by them shall be filed on or before the next date of the. Mr. Das, there is a similar matter, engineering college, same that the
age, regarding age.
Age, this one only.
No, my lord. My lord, here some.
That went up to the division
facts
bench.
are little bit different, my lord. Another
That
case is
matter went
pending.
up to the division bench.
That is with regard to, I think.
No, same thing.
Age
Because
only, age 65 years.
He completed 60. Then he was given promotion. That promotion was not given effect to. Subsequently, it went up.
Yes, that
there is a single judge order.
Yes, ma'am.
Then the matter, it was an engineering college.
Satyajit Paul, my lord.
Satyajit Paul. Where is that order?
But that is different facts, my lord. Here facts are different, my lord. Here, my lord, the petitioner was working in Cotton College, my lord. That was under the government. Subsequently, Cotton College became Cotton University. When the Cotton College became Cotton University, the Act, Cotton University Act says that the petitioners and those similarly situated persons have been placed under special cadre, my lord. And for the petitioners under the college, my lord, we have been paying the salary. Now he has been promoted to, my lord, as a professor. Now, my lord, in non-technical colleges.
Not promoted as a professor.
In non-technical colleges, my lord, under the government of Assam, there is no there is no post of professor, my lord. And as soon as and when the petitioner got promoted to professor, he become the faculty of university, and university is, my lord, is autonomous body. We do not have, my lord, power over that.
But the Learned Counsel for the parties as agreed to, the pleadings are complete in the matter.
My lord.
No, the affidavit, we have not received any affidavits.
The affidavit has been filed, my lord.
When it will file?
Fine. Respondent number 3 and 4. 3 and 4 is you.
2, 4, 2. Lordship, I'll check.
No, state has not filed, I suppose.
It's a cool, sir.
Affidavit has been.
Respondent number 2 in the second case, 69.
In 5934 2024.
5934 affidavit has already been filed.
Yes,
Filed, my lord.
this
So
one.
that will
Cover, my lord.
submits that the pleadings in the matter is complete. Also, and the matter can be taken up for final disposal. As agreed to by the Learned Counsel for the parties, registry to list this matter again on 37/2026 for admission hearing.
Mr.
B. Sharma,
Cotton University Act, it is in our favor. Cabinet decision is there for extension.
check up Satyajit Paul. There is one line somewhere
Satyajit
there.
Paul, my lord, what had happened there? Satyajit Paul, he was, my lord, in the same institute, my lord, under the government of
Got
India.
it, got it. Look,
Obliged.
correctly admission. No, no, that's it. 21 at Asan. None appears for the petitioner on call. As similar matters have fixed on 16/6/2026, registry to list the present matter also on 16/6/2026. Yeah. So who's the total regulation about? Board regulation, Kavakata Bele, huh?
My lord, on that day, when Lordship has told about this marking, my lord, I have come across, my lord, that 15 marks not for teaching experience, my lord. It is a marks for due weightage and plus including 3 marks for this this teaching experience and other due weightage. And I have gone through the minutes. They are saying that this due weightage and I have gone through the Google, my lord, the difference of teaching experience and the experience as a whole for performance matter.
Under what category they are marked?
That they will justify, my lord, governing body. Let them clarify the matter.
Decided to award weightage to so-and-so in experience.
That
Experience is clause 7.
No, my lord, only my prayer is this, my lord. Since that it is stated in the minutes, my lord.
This court directed only with regard to
Due weightage.
considering
And
teaching experience. That's all.
my lord,
Okay, you make your submissions. We'll record that.
my lord, only for your lordships, for my clarification, just for my lord. On the basis of this honorable court's order, the director has issued an order, my lord, on 28/3/2024 for compliance, my lord. 28/3/2024, and accordingly,
That is not on record.
this is, my lord, lordship will find in the minutes itself, my lord. Page 50, lordship. Page 50, I am reading, my lord. The selection committee meeting for selection of candidate for the post of assistant professor in the Department of Hindi, UR, Shankardev Mahavidyalaya, Pathali Pahar, was held in the office of the principal under the chairmanship of Mr. Swayan Birendranath Bhagavati, President, Governing Body, Shankardev Mahavidyalaya, 13th May 2024 from 11 a.m. The selection committee for review and compliance of the selection assistant professor in Hindi held today on 13th May 2024 in the principal chamber, Shankardev Mahavidyalaya, Pathali Pahar, Lakhimpur, Assam, in respect of DH's by letter number so and so 28/3/2024, my lord, as per the letter of the DH's. And my lord, in accordance with the committee's review and made complaint in respect of Honorable Gauhati High Court's order dated so and so, passed in WPC so and so, and contempt case number so and so, Srimati Gitali Bordole so and so, decided to award weightage, my lord, decide to award weightage to Mrs. Gitali Das in experience mark. It is not teaching experience.
Please read further.
In place of 3 earlier given.
So now you are being considered, Mr. Chetri, the petitioner is being considered against 112 marks, not 100 marks.
My lord, this is, of course, my lord, this is this 12 marks excess, probably 3 marks, including 3 marks, my lord.
That's why I did not say 15, I said 12.
Yes.
I have deducted 3.
Exactly.
12.
12.
So now you will be considered in 112, whereas all others have been considered in 100.
No, here, my lord, this, as per this honorable court order, that has been complied with, my lord. And this, my lord, around 21 years today, as on today, and I was the head HOD for 8 years, and all along NCC officers, my lord, in charge for about 8 years, and the whole activities I have carried out, and this is done in terms of the honorable court's order, my lord. And that honorable court's order is remain in force, and this selection is also not been under challenge by anybody else, my lord.
We will deal with it.
And lordship will consider that since this.
You have also taken the plea that if this court is to take a contrary view to the view taken by the coordinate benches, then I'll have to refer it. That will only come if I take a contrary view.
Yes.
If I don't take a contrary view, then I did not refer.
No, since my lord, only probably my understanding, my lord.
My understanding may be wrong.
No, yes, lordship's understanding is far better, my lord. My lord, only my understanding
is subject to the superior court's orders.
My lord, here, this this honorable Supreme Court also said, my lord, regarding this selection committee, this is in case of, my lord,
you want to argue the matter again?
Argue, my lord, at this point, my lord, on
see, I'm to pass the order.
Yes.
If you want to argue, if you require time, tell me, I'll hear the matter again. Otherwise, I'll pass the orders.
Because I have to rely on some of the judgment that already I have supplied. Probably lordship has gone through it.
All gone through.
Tasveer Singh Sodhi, para 12. That is very clear, my lord.
Show me. That Jammu Kashmir case.
Lordship.
Para 12.
It could clear.
No issue, no dispute on this. No dispute on this.
My lord, only 12.
Tell me one thing, Mr. Khatri. What are the powers of a selection committee? And when the selection committee can devise a method on its own? When a selection committee is constituted and the manner of selection is not laid down, the selection committee can devise its own method. Right? That is the decision of my Lord Justice Chandrachud in Srinivas K. Gowda. But here, selection committee has been constituted. But it is constituted with a prescription that it will be academic 70, research and experience 30. How? This. Selection committee's objective or the subjective satisfaction would be only for 5 marks. That is the interview marks. Other than that, they are bound to follow the prescription in the office memorandum. Now, this court said to consider. I'll disclose what I'm thinking. To consider. Now, to consider means to consider in terms of the guidelines, rules, act, whatever it is, in full. The selection committee went beyond the orders of this. This court never said give him 15 marks. They could not have gone because this court did not put a further stipulation that the restriction of 3 marks, you said records were there, restriction of 3 marks we remove. That was not done. It could not have done because it could not have done passed a mandamus to act illegally. This court cannot pass a mandamus to act illegally. Reserve your Baki strength for the epi.
No, only my anxiety before this honorable court and my very humble prayer before this honorable court is this. Since I have also gone through some of the decision, my lord, to when court pass any order, my lord, this honorable court pass any order to give the due weightage, my lord. I have gone through, my lord, some of the judgment.
It can be when your own case. My Lord Justice Gogoi's order, in you got that order in the Bangla peons case. This court laid down that weightage should be given for their service rendered, because there was no prescription made, right? People got the relief. You were there. You were the counsel. We followed that decision when we were practicing subsequently. You took out that decision from my Lord Justice Gogoi. There it is fine. But here, there is a prescription. Until and unless that prescription is taken out of the way, how can I pass a direction?
My Lord,
It will be a dangerous precedent.
my Lord, otherwise also, since this selection, my Lord, not under challenge by anybody else, and this is in force as on today, my Lord. And I have
Yes,
come before this
because
honorable
that
court.
selection was all along kept in abeyance by this court.
No, my Lord,
Otherwise also, my lord.
the proposal has not been considered by the director as on today, my Lord. It is pending. No speaking order, nothing else regarding the proposal sent by the selection committee. Only one.
Affidavits have come, everything has come, we will consider that.
My lord,
Don't worry.
as soon as the committee, my lord, reviewed its own order, the earlier recommendation or the decision taken by the committee has gone, my lord. Now the only existing decision is the recent one, my lord.
Otherwise,
So if we go
My
in
lord.
favor of Mr.
Even
Chetri,
if-
that's a different thing
No, my lord.
altogether. If we go against Mr. Chetri, what will happen to this election? You will have to
No,
do it
even if, my
afresh.
lord, even if the recommendation of the selection committee has to be placed before the director, there has to be the decision of the reviewed order, my lord, reviewed decision, my lord.
Now we are
Where-
not
where
doing
has
it.
been given,
No, we
50
set aside the review decision. That will revive the earlier decision.
Man.
Now, because of this length of time that has lapsed now, maybe they are not interested, whoever was selected has not even come up. So under that circumstances, we leave it to the director to take a call for a fresh selection in the matter.
Fresh selection, my lord,
For that advertisement,
advertisement and yes,
everything
my lord.
fresh.
That
And
can
if the
be-
petitioner is entitled, eligible,
he will participate.
now-
and with the, you can even, she can even apply before you for
My
condonation.
lord,
now I have already 45 years.
You can apply for condonation.
my lord.
They'll consider.
That can be right.
Otherwise, nothing will happen.
Don't want that. Okay. We
No.
ignore that. But Mr. P. Chetri, Learned Counsel for the petitioner. Also heard Mr. S. Das, Learned Standing Counsel,
Higher education, my
Higher
lord.
Education Department.
I'll be appearing
And there
for-
was somebody more.
I'll be
Respondent
appearing for 1 and 2, my lord.
for appearing for the respondents number 1 and 2. Anybody for the
Inspect-
college? No.
Inspector of school.
Huh?
And they have not appeared as on today, my lord. That is why, my lord, I said, my lord, this appropriate authority is the this selection
None
committee
has
and the
appeared
GB
for the,
to file the affidavit, my lord.
none has appeared for the respondents number 3 and 4. 3, 4 and
3, 4 and 5.
So, the petitioner,
My lord, only, I'm sorry, my lord. Very sorry, my lord. Once again, I will read out this paragraph 12, my lord. Then Lord
I
will,
accept that. I accept that.
their last one, Lord.
12, I accept it. Jammu Kashmir case,
Yes.
no doubt about it. But in our case here, it is circumscribed. That power is circumscribed. It cannot go beyond what is there.
The last para. Just I'm reading for my satisfaction. Then
Yes,
Lordship
yes.
will pass.
Your satisfaction is also of great importance. It's also an important matter.
12, my lord,
The law on the scope and extent of so and so may be understood on so and so. Yes.
12. Before proceeding further, it is necessary to preface our judgment with view that courts in India generally avoid interfering in the selection process of public employment, recognizing the importance of the maintaining of the autonomy and the integrity of the selection process. The courts recognizes that the process of selection involves a high degree of expertise and discretion, that it is not appropriate for courts to substitute their judgment for that of a selection committee. It would be indeed treading on thin ice for us if we were to venture into reviewing the decision of experts who from a part of the selection board, the law on the scope and expert of the judicial review of a selection process and results thereof may be understood on consideration of the following case law. In Dalpat Asasab Salunke so and so 1990. It is needless to emphasize that it is not the function of the court to hear appeals over the decision of the selection committees and to scrutinize the relative merits of the candidates,
whether candidate is a fit for particular post or not has to be decided by the duly constituted selection committee, which was the expertise on the subject. The court has no such expertise. The decision of the selection committee can be interfered with only on limited grounds such as illegality or patent material irregularity in the constitution of the committee or its procedure vitiating selection or proved mala fide affecting the selection process, etc. In a similar vein, in Secretary so-and-so Department so-and-so 1996 6 SEC, this court observed as regard the sanctity of the selection process and the grounds on which the result thereof may be interfered. It is too well settled that when a selection is made by an expert body like the Public Service Commission, which is also advised to expert having technical experience and a high academic qualification in the field of for which the selection is to be made, the court should be slow to interfere with the opinion expressed by the expert unless allegations of mala fide are made and established. It would be prudent and safe for the courts to leave the decision on such matters to the experts who are more familiar with the problems they face than the courts. If the expert body considers suitability of a candidate for a specified post after giving due consideration on all the relevant factors, then the court should not ordinarily interfere with such selection and evaluation. This position was rated by this court in 2008 ACC. Now, 21 comes to the question with regard to the selection of the candidates normally. The recommendation of the selection committee cannot be a challenge except on the ground of mala fide or serious violation of the statutory rules. The courts cannot sit as an appellate authority to examine the recommendation of the selection committee like the Court of Appeal. This discretion has been given to the selection committee only, and courts rarely sit as a Court of Appeal to examine the selection of the candidates, nor is the business of the court to examine its candidates and record its opinion. 30. We fail to understand how the tribunal can sit as an appellate authority to call for the personnel records and constitute selection committee to undertake this exercise. This power is not given to the tribunal, and it should be clearly understood that the assessment of the selection committee is not subject to appeal either before the tribunal or by the courts. One has to give credit to the selection committee for making their assessment, and it is not subject to appeal. Taking the overall view of the ACRs of the candidate, one may be held to be very good and another may be held to be good. If this type of interference is permitted, then it would virtually amount that the tribunals and the high courts have started sitting as selection committee or act as an appellate authority over the selection. It is not their domain. It should be clearly understood, as has been clearly held by this court in a number of decisions. Om Prakash Poplai and Rakesh Kumar Maheshwari, so-and-so, 1994 to SEC 117. And this selection of members expert committee now does, Lordship, lastly, does the court, while exercising the power of judicial review, cannot step into the shoes of the selection committee or assume an appellate role to examine whether the marks awarded by the selection committee in the Bhaiva Bhusha are excessive and not corresponding to their performance in such tests. The assessment and evaluation of the performance of candidates appearing before the selection committee interview board should be best left to the members of the committee. In light of this position that a court cannot sit in appeal against the decision taken pursuant to a reasonably sound selection process, the following grounds raised by the writ petitioner, which are based on an attack of subject criteria employed by the selection board interview panel in assessing the suitability candidates, namely that the candidates who had done their post-graduation had been awarded 10 marks, and in the Bhaiva Bhusha, such as PG candidates had been granted 18 marks or 20 marks out of 20, that although the petitioner had performed exceptionally well in the interview, the authorities had acted in an arbitrary manner while carrying out the selection process would not hold any water. These are the things, my lord, when one selection committee has considered all this aspect, my lord. So, my lord, at this stage, only my prayer will be
Secretary, subject to my view being corrected by the superior courts. That judgment is with regard to the selection committee marking the candidates. candidates, 10 candidates appear before the selection committee. How the selection committee marks candidate number 1 to candidate number 10 is for them. But if there is a marking procedure already given, they cannot violate that.
But here, my lord, since the earlier single bench order was complied with by issuing an order from the director itself, my lord, on 28/3/2024. Had there been any, when the due weightage, regarding due weightage, had there been any
Director
irregularity?
also cannot violate that.
No, we are not on that, my lord. That order has been complied with. Once that order has been complied with by the selection committee, can we go again back to the
Because that
shoes of
director has
the
not
selection
accept-
committee?
Rightly, wrongly, the director has not accepted it, and you are before this.
No, my lord, director has not accepted.
Because
as on
you
today,
want,
my lord,
Mr. Chetri, your prayer is for implementation of the minutes of the selection committee.
Fresh one.
the director has passed an speaking order on the basis of the old letter of the principal, not
we
the selection
consider.
committees.
You hear, we are considering that also. I'll say that also. Then I'll give my reasons. Don't
And
worry.
as on today, the selection committee, this committee's proposal is in force.
We'll see only whether that selection committee proposal is in tune with the directions passed by this. Find that it's in tune, fine. If not in tune, we'll go ahead.
So Lordship will consider that aspect. And
But Mr. Sublikilana, the petitioner, by way of instituting the present writ petition, has presented a challenge to an speaking order, to an order dated 19/8/2024, issued by the Director of Higher Education, Assam, holding therein that the petitioner, having been granted full weightage for teaching experience, that is 3 out of 3 marks, as per the guidelines in vogue, the directions passed by this court-wide order dated 21/11/2023 in WPC number 7667/2019 stood complied with. Also, the facts in brief requisite for adjudication of the issues arising in the present writ petition is noticed as under. The petitioner has projected in the writ petition that she has all the requisite qualifications for being, she had all the requisite qualifications for being appointed as a lecturer, bracket now assistant professor in the subject of Hindi. Also, it is further projected that the governing body of Mr. Chetri, Shankardeva Mahavidyalaya, in its meeting held on 25/8/2005, recognizing the need of a experienced, of a qualified person to teach the subject of Hindi in the college, had required an engagement of a qualified person in this connection. Accordingly, the petitioner was required by the principal of the college to submit an application for engagement as assistant professor. So, assistant professor, assistant professor in Hindi against a non-sanctioned post. The petitioner accordingly applied by submitting her qualification, by also enclosing the qualifications process by her. So the respondent, the authorities of the college, on being satisfied that the petitioner was suitable for such appointment, proceeded to appoint the petitioner. Proceeded by order dated 25/8/2005 to appoint the petitioner as lecturer in Hindi on ad hoc basis. So the petitioner, having continued in her services after her appointment was so affected by the order dated 25/8/2005 against a non-sanctioned post on ad hoc basis, the name of the petitioner was also placed by the college authorities before the director and had shown her to be an existing employee in the school, in the college. So, at this stage, a vacancy had arisen in the Department of Hindi when incumbent in a sanctioned post of assistant professor therein had died in harness on 19/6/2014. Also, the petitioner, by projecting that she had fulfilled all the requisite qualifications mandated for appointment against a sanctioned post of assistant professor, approached the Director of Higher Education Assam through the principal of the college, vide a representation dated 17/4/2017, praying for regularization of her services. As the said application, a representation submitted by the petitioner was being processed, the Director of Higher Education Assam, vide a communication dated 26/7/2019, proceeded to issue an advertisement, proceeded to direct for filling up of the vacant post of sanctioned vacant post of assistant professor in the department, arising in the Department of Hindi in the college by way of direct recruitment. Accordingly, the principal of the college published an advertisement on 6/8/2019 in the News Daily Ahomia Proceeding ', inviting applications along with other posts, for the post of assistant professor in Hindi. Also, the petitioner herein being eligible applied against the said advertisement for the post of recruitment against the post of assistant professor in Hindi. It is further projected by the petitioner in the petition that a call letter was issued to the petitioner on 27/9/2019, requiring her to appear in the interview, which was scheduled on 21/10/2019. Para. It is further projected that the petitioner, after receipt of the call letter for appearing in the interview, had submitted a representation before the chairman of the governing body through proper channel, praying on 9/10/2019, praying for consideration of her case for recruitment against the advertised post of assistant professor in Hindi, by also reckoning the 15 years of continuous service rendered by her as a assistant professor on Hindi, assistant professor of Hindi on ad hoc basis. Also,
now it is 21 years.
10, 15. Mr. Petri, that day I did not pass this order because I myself was disturbed. Today I am clear. I have been able to balance out. We are also human beings. It's not that we are dehorsed the feeling. Cannot be. Also, the petitioner at this stage had approached this court by way of instituting a writ petition, being WPC number 7667/2019. In the said writ petition, it is projected that the petitioner had assailed the advertisement dated 6/8/2019, and had also prayed for regularization of her services. A coordinate bench of this court, wide order dated 16/10/2019, had required the petitioner to appear in the interview, which was scheduled on 21/10/2019. Also, the petitioner thereafter instituted a interlocutory application, being IA-C number 3348/2019, praying for a direction upon the respondent authorities to consider the 15 years long service experience gathered by her as an assistant professor in Hindi in the college, while considering a case for regularization. Also, a coordinate bench of this court, wide order dated 21/10/2019, upon upon noticing the submissions made by the learned counsel of the petitioner that proceeded wide proceeded wide order dated, a coordinate bench of this court, upon appreciating the issues arising in the said interlocutory application, proceeded wide order dated 21/10/2019 to dispose of the same by directing the respondent authorities to take into consideration the long 15 years of experience in service gathered by the applicant, public writ petitioner, therein at the time of selection for the post of assistant professor in Hindi in the aforesaid Mahavidyalaya. The coordinate bench heard wide an order dated 21/10/2019 passed in the connected writ petition being WPC number 7667/2019 by noticing that the recruitment process for appointment to the post of assistant professor as advertised was already initiated, directed that any appointment to the said post shall not be made without leave of this court. So it is to be noted that the petitioner, during the consideration of the issues arising in I/C number 3348/2019, had apprised this court that on the same day at 9:30 a.m., she had already appeared in the selection before the interview committee. Also, it is to be noted here in that the selection committee on 21/10/2019 had already considered the cases, considered the candidates appearing before it for the post of assistant professor in Hindi as advertised by the advertisement dated 6/8/2019 and had selected one Uza Borua for appointment against the said post. Also, the the 1 to 3, 3.1, 3.2 and again. The writ petition being WPC number 7667/2019 was thereafter taken up for final consideration by this court. And this court, wide order dated judgment and order dated 21/11/2023, noticing the submission of the noticing the directions passed by this court in the interlocutory application being IA/C number 3348/2019, and further appreciating that the direction passed therein was not permissible to be considered by the selection committee, inasmuch as the copies of the order dated 21/10/2019 was placed before the governing body of the college only after the selection process was concluded by the selection committee. So, having considered the said position, this court remanded the matter back to the selection committee of the college to comply with the direction contained in the order dated 21/10/2019, passed in IA/C number 7667 3348/2019. By taking note of 15 years of experience of the petitioner to give adequate weightage in the selection process, and thereafter to bring the process to its logical conclusion. So, although the director of higher education, although the principal of the college wide a communication dated the principal of the college thereafter wide a communication dated 15/12/2023 had approached the director of higher education seeking guidance with regard to the manner in which the matter is to be now proceeded. It is projected that in terms of the directions issued by the Director of Higher Education, Assam, the governing body of the college in its meeting convened on 30/4/2024 adopted a resolution to the effect that to comply with the directions passed by this court in WPC number 7667/2019, the selection committee is being reconvened. Accordingly, the selection committee on being reconvened met on 13/5/2024. The selection committee, noticing the directions passed by this court on wide order dated 21/10/1999 in WPC number 7667/2019, proceeded to review its earlier recommendations made in the matter, and by complying with the directions passed by this court, decided to award weightage to the petitioner in experience criteria, in experience marks 15 in place of 3. It was clarified in the order that the 3 marks granted earlier was so granted as per UGC and DHE apostrophe S guidelines. The recommendations made by the selection committee on being placed before the governing body in its meeting held on the same day, that is on 13/5/2024, accepted the same and decided to forward the matter to the director for information and necessary, Director of Higher Education for information and necessary action. The recommendation made by the selection committee and the approval thereof by the governing body of the college, along with all requisite materials, requisite documents, were forwarded by the principal of the college to the Director of Higher Education, Kailipara, wide communication dated 18/5/2024. Also, it is in the above background that the director had passed the speaking order dated 19/8/2024. Being aggrieved, the petitioner has instituted the present writ petition. No facts left out?
Only, this director's letter, I am not against the director's letter because this order was passed on the basis of the old letters of the.
I'll come to that.
But not on the.
No, this is just the preliminary facts. That is your argument. We'll record it. Don't worry. I'll not forget that.
This selection committee is still enforcement.
That is why I love Mr. Chetri. He is fighter. This is a good quality. Maybe annoying sometime, but it's good. I like it because I was that side. I like that. And please feel free to tell me anything, even if when I'm dictating. I don't mind. I want my order to be correct.
Yeah,
correct. That's it. Mr. B. Chetri, Learned Counsel for the petitioner, by reiterating the facts noticed herein above. at the outset has submitted that the directions passed by this court wide order dated 21/10/2019 in I bracketed C number 3348/2019, requiring the respondent authorities to take into consideration the long 15 years of experience gathered by the petitioner as as an assistant professor in Hindi in the said college while considering a case for selection was not immediately complied with by the respondent authorities. The respondent authorities had taken a plea to the effect that the said directions were received by the college authorities only after the selection committee had concluded its selection, had concluded the selection. He submits that thereafter, when the matter was taken up for final consideration by this court, when thereafter, when WPC number 7/667/2019 was taken up for final consideration by this court, this court had required the respondent authorities to produce the relevant records of the selection. He submits that the records of the selection were perused by the coordinate bench of this court, and on such perusal, and upon such perusal, and noticing the directions passed wide order dated 21/10/2019 in I bracketed C number 3348/2019, proceeded to hold that the reasoning advanced by the college authorities that the interview process having been completed before the receipt of the order, said order dated 21/10/2019, to be not a good ground, to be not a reason for the college authorities not to follow the directions of the court or not to give due consideration to the 15 years of experience of the teacher. He submits that accordingly, the matter was remanded back to the selection committee with specific direction to consider the 15 years of experience of the petitioner and to give due adequate weightage thereof in the selection process. He submits that in pursuance to the directions passed by this court, by the said order, judgment and order dated 21/11/2023, the governing body, on consideration of the same and also upon receiving necessary clarifications in the matter from the Director of Higher Education Assam, had directed for reconvening of the selection committee meeting. He submits that the selection committee thereafter, on being reconvened, met on 13/5/2024, and on a review by way of a review of its earlier recommendation, proceeded to select the petitioner by giving her weightage for the 15 years of experience, teaching experience she had gathered in the college, and awarding 15 marks for the purpose. Mr. Chetri submits that the said decision of the governing of the selection committee as per the procedure mandated was to be placed before the governing body of the college. He submits that the same, on being placed before the governing body of the college, the said recommendation was accepted. Accordingly, Mr. Chetri submits that the directions passed by this court widely order dated 21/11/2023 in WPC number 7/667/2019 stood complied with. The review of the selection process being so made by the selection committee in terms of the directions passed by this court, comma, the Director Higher Education could not have sat over the same as an appellate authority and was required to grant approval to the same, leading to the appointment of the petitioner as assistant professor in Hindi against the post so advertised by the advertisement dated 6/8/2019. Mr. Chetri further submits that the directions passed by this court, by the coordinate bench of this court, while judgment and order dated 21/11/2023 in WPC number 7667/2014 has since attained finality in absence of a challenge being presented to the same. He submits that the decision of the selection committee to review its earlier decision and now to recommend the petitioner in the manner indicated herein above for the post of assistant professor in Hindi also not being challenged by any aggrieved person, comma, the same also has to be held to have attained its finality. Accordingly, he submits that the Director, Higher Education, Assam, could not have proceeded to pass the speaking order dated 19/8/2024 without first factoring in the said developments taking place after the issuance of the communication dated 18/4/2024 by the principal of the college. He submits that the director had, for the purpose of depriving the petitioner of her due appointment in terms of the recommendations now made in her favor by the selection committee, had deliberately not considered the developments taking place subsequent to the passing of the directions by this court in subsequent to the issuance by her of the communication dated 28/3/2024. Accordingly, he submits that the order dated 19/8/2024 would mandate an interference from this court. Also, Mr. Chetri, by referring to the order dated 7/6/67/2019 passed by this coordinate bench of this court, by referring to the order dated 21/11/2023 passed by this court in WPC number 7667/2019, submits that the court, while passing the directions as contained therein, was apprised that the court, while passing the said so and so, had passed the said directions after being apprised about the existence of the guidelines notified, while the notification dated 8/11/2018. Accordingly, he submits that this court, having also appreciated the notification dated 8/11/2018 and thereafter directed the selection committee to consider the case of the petitioner in the manner as directed, there cannot be a contention raised by the respondents that the selection committee, by making the consideration as made by it in its meeting held on 13/5/2024, had violated the guidelines as notified, while the notification dated 8/11/2018. Mr. Chetri, in view of the deliberations taking place in the matter, has made a further submission to the effect that in the event this court is of the view, is proceeding to take a view contrary to the one taken by the coordinate bench of this court, by judgment and order dated 21/11/2023 in WPC number 7667/2019, the view taken by the coordinate bench being binding on this bench, this court would be required to refer the matter to a larger bench for a consideration. He submits that it would not be proper for this court to proceed to consider the issue raised in the present writ petition by taking a contrary view than that taken by the coordinate bench in the proceedings of WPC number 7667/2019. Also, next, Mr. Chetri, in support of his submissions, has placed reliance on the following decisions of the Honorable Supreme Court. 1. (1990) Supply SCC 157. Sridhar versus Nagarpalika, Jaunpur. Sridhar. 1, 2, 3 co-edition. 1. Tajvir Singh Sodhi. 2. Srinivas K. Gowda. 3. Sandhya Educational Society. 4. Other 2 is required. 24 Supreme Court, I don't think so is required. Jyotishmita Goswami.
Jyotishmita Goswami, regarding the selection committee, once it is recommended, the director is bound to being approval.
Jyotishmita Goswami and Fusa. He has also relied upon next the following decision of this court in the case of has also relied on a decision of this court in the case of Jyotishmita Goswami versus
State of Assam
and others, reported in 2016, 5 TLT 1/5 Also, in the above premises, Mr. Petri has submitted that the decision of the selection committee has arrived at in its meeting, selection committee of the college has arrived at in its meeting held on 13/5/2024 and approved by the governing body of the college in its meeting held on 13/5/2024 and not being set aside subsequently by any authority and or by this court, would be required to be directed, to be complied with, to be implemented. Accordingly, he submits that he prays that a direction be issued to the Director, Higher Education, Assam, to implement the decision of the selection committee as approved by the governing body of the college and to appoint the petitioner against the post of Assistant Professor Hindi expeditiously. I think everything has come, Mr. Petri. Per contra, Mr. S. Das, Learned Standing Counsel, Higher Education Department, at the outset submits that with regard to the selection against the post of assistant professors and librarians, comma, the government of Assam in the higher education department has been laying down the guidelines required to be so followed by the college authorities as well as by the selection committee. He submits that the government in the higher education department, wide office memorandum dated 8/11/2018, in supersession of its earlier guidelines, had set out the guidelines for selection against the post of assistant professors / librarians in provincialized colleges of the state. He submits that the said guidelines have been so framed by following. Mr. Das, just write down that UGC minimum, that whole thing, na 2010, just write down.
I'll give my.
Following the UGC regulation to pura likhi diba. Prescriptions made in the UGC regulations of 2010. Mr. Das submits that in the said office memorandum dated 8/11/2018, the distribution of marks with regard to the selection for recruitment to the post of assistant professor / librarian has been laid down He submits that for academic record, 70 marks have been earmarked, whereas for research contribution and experience, 25 marks have been earmarked. The balance 5 marks is so prescribed for being awarded by the selection committee after the interaction with the candidate concerned. He submits that the marking pattern as set out in the said office memorandum dated 8/11/2018 is binding on the selection committee, and the selection committee, insofar as provincialized colleges in the state are concerned, do not have the discretion to devise a methodology for the selection in question. The selection is required to be strictly undertaken by the selection committee in terms of the provisions of the said office memorandum dated 8/11/2018. Mr. Mr. Das has further submitted that in terms of the said office memorandum, said office memorandum, for teaching / library management experience in the concerned subject / domain, it has been stipulated that 1 mark for each completed year of service after acquiring UGC norms in provincialized / government / affiliated degree colleges / libraries of government institutes shall be awarded subject to a maximum of 3 marks. Accordingly, he submits that there is a cap of 3 marks with regard to award of marks under the heading teaching experience to a candidate appearing in the selection process. So, Mr. Das, by referring to the orders passed by the coordinate benches of this court in interlocutory IA bracketed civil number 3348/2019, as well as the judgment and order dated 21/11/2023 in WPC number 7667/2019, has submitted that the coordinate benches of this court had only required the respondent authorities / selection committee of the college to take into note take into consideration the 15 years of experience of the petitioner to give due adequate weightage in the selection process, and thereafter to bring the process to its logical conclusion. He submits that considering the nature of the directions passed by the coordinate bench of this court as noticed herein above, the selection committee, while extending the consideration as directed to be extended to the petitioner by this court, cannot ignore the mandatory prescriptions made in the office memorandum dated 8/11/2018. He submits that the said consideration is required to be extended by the selection committee to the petitioner by confining itself within the parameters set out in the said office memorandum dated 8/11/2018. Next, Mr. Das has further submitted that a perusal of the minutes of the meeting of the selection committee held on 13/5/2024 would reveal that the selection committee has misconstrued the directions passed by this court in WPC number 7667/2019. He submits that on account of such error committed by on account of the directions passed by this court being misconstrued, the selection committee had proceeded to award 15 marks to the petitioner against teaching experience and thereby recommending her for appointment against the post of assistant professor Hindi as advertised by the advertisement dated 6/8/2019. Mr. Das submits that there was no direction passed by the coordinate bench of this court in the proceedings of WPC number 7667/2019 for awarding 15 marks to the petitioner for the teaching experience and or to consider the case of the petitioner by ignoring the mandatory prescriptions made in the office memorandum dated 8/11/2018 in this connection. Accordingly, he submits that the selection committee had exceeded its jurisdiction in the matter. So he submits that the selection committee the decision of the selection committee being found to be in violation of the office memorandum dated so and so, its mere approval granted thereto by the governing body of the college would not make such vitiated recommendations to be implementable. Mr. Das has further submitted that the petitioner in the proceedings of WPC number, neither in the proceedings of WPC number 7667/2017, 2019, nor in the present proceedings has presented a challenge to the stipulations as contained in the office memorandum dated 8/11/2018, including the cap mandated therein of 3 marks for teaching experience. I cannot put it. बाप रे बाप, not told you. In the above premises, none. the last issue. In the above premises, it is submitted that the claim made by the petitioner in the present petition would not mandate an acceptance from this claim.
And directory is not a rubber stamp, my lord. That my lord is also fine.
Up to that.
Yes, yes.
Not a rubber stamp, but in some cases they act like rubber stamp. That's the problem. We'll continue at 2. Immediate 2000. 2 o'clock will. Ask him to give me the details, complete details, whatever it is. This is not the way you deal with a High Court's order.
The order is serviceable is not to come to the court. Then for another serviceable can be on this order. I will take this.
We'll see.
50 to 50.
We'll see. We'll see. Let it reach with it. May reach. If it doesn't reach, we'll see. You need not be here. We'll see. Yes. You are there.
I'm for respondent number 4.
Right. I have some matters may not. Reach. If it reaches, I'll pass. You be please be 52. 52. Not too bad. You all need not be here. If that is the thing, we'll direct for fresh steps.
Obliged.
You are appearing for Mr. Sharma?
I'm for respondent number 4. The earlier, my lord, order because the respondent number 9 was a necessary party to settle this whole issue of payment to the petitioner. So respondent 9 has been implemented later. Not implemented, but it was notice was not issued initially, but then subsequently notice was issued. But AD card has not come back. So my learned friend says that he was not well, so he wanted to mention the matter.
Please go. We'll take care. Mr. Mehdi, you leave. Please don't worry about it.
Respondent 9.
We'll do the needful. Don't worry. You just check up online tomorrow what has happened. So, Soma, you also need not wait. You also need not.
Obliged.
Mr. Borua, you have submitted the audit, whatever documents are required for audit, but the bank statement could not
That
be.
was not completed because of that documents, my lord. Page, my lord, kindly say page 45. He was the DDO. Since our suspension and reinstated, that also I was not access of that documents. Then I approached him. So for last 2 years, not provided, my lord. So without that, my lord, this account, so I cannot. Otherwise, everything is for this week.
No ego involved.
He was in
Not
charge of
any ego involved.
I do not know, my lord.
No, your petitioner.
Petitioner always approach, my lord. Now,
Let him come, we'll see. Yes, Mr. Kulta.
Good afternoon, sir.
It's your dairy where Simon.
Sir, Pores Dekar Kotatu Okonman Digolia. Sir, Pores Deka visited. I have given him provisional pension already. And sir, I was supposed
that is
to.
Not something which you have given from your end. That is by legally entitled.
Yes, sir. And then we were supposed to provide him the process for the final pension. Then one day he submitted a final pension proposal where the NOC and NLC was fake. Actually, he signed his NOC and NLC by himself with his signature, but in NOC and NLC, signature should be of DDO and the SMDC president. He never visited DDO, he never visited, and he was not the DDO, sir, because he was suspended and reinstated in IS office. He was never reinstated in the school.
Okay,
and once
what has happened has happened.
Sir.
Mr. Kulta, what has happened has happened. Now, he was never the DDO.
Yes, sir.
So there is somebody
He
else,
was never a DDO.
somebody else is acting as a DDO.
I am acting as a DDO.
So, have you given him the requisite bank statements, etc., whatever are required to be given to audit?
Sir, bank statement is with me. I have collected it. And sir, I have written to audit office also that his audit should be done. Audit office has given a long list of documents. And sir, in the audit documents, SMDC's signature is required. And he was reinstated in IS office. And after his reinstation, it was said that he never ever visited the school and he never ever submitted any documents of his tenure to
What are the
SMDC.
documents he is to give now?
He has to give, sir, bank statement of
That is
all
with
the
you.
bank accounts.
Your DDO bank statement is with you. Then next.
Sir, I have again, he need to give cash book voucher. Sir, he has to give
These
the
cash
stock
book
book
vouchers
register.
Mr. Kolta, these cash book vouchers are in his possession or in possession of the school?
In his possession, sir, after he joined in IS office, he never visited school and never submitted any documents in school.
I am requiring him to appear before you on Monday.
Sir, I will give him all the documents required by me in written to him. He has to submit it to me, sir.
Just a
Yes,
moment.
sir.
He will appear
Okay, sir.
before you on Monday.
Okay, sir.
11 o'clock, he will be in your office. Fine?
Okay, sir. Okay.
By
Sure, sir.
Friday, you
Sure,
make out
sure,
a
sir.
letter to him wherein the documents he has to submit to the audit. Kindly let him know that.
Yes, sir.
He will then go to the school,
Yes, sir.
collect those documents, and you
Yes, sir.
instruct on
Yes.
Friday itself that Monday or Tuesday the man is coming to the school. The school authorities will facilitate giving him the documents, whatever is not with him. By Friday
Sure, sir.
next, he will submit the documents to you or to the audit as the case may be. Within
Okay, sir.
1 month, audit has 1 month. From the date
Okay,
of
sir.
submission, 1 month, the audit report have to come. Thereafter,
Okay,
1
sir.
month, you will have to submit his
Yes,
pension.
sir. Yes, sir. Sure, sir. Sure,
Done?
sir. Okay, sir.
Okay, Mr. Kolta,
Okay.
do whatever
Sure,
you
sir.
at your disposal. Get this matter sorted out, and if the petitioner has
Yes,
done
sir.
something which is a misconduct,
Yes, sir.
kindly bring it to our notice, or if it is permissible, take action at your end. You have liberty for that.
Sure, sir. Sure, sir. Sure, sir. Thank you, sir. Thank you. Thank you, sir.
What Kolita is?
Tapan
Kolita, Inspector of Schools, Kamrup Rural, was present by way of video conferencing, had appeared before this court by way of video conferencing. Mr. Kolta has submitted that certain documents have to be submitted by the petitioner for completion of the audit for the period he had held the charge of headmaster of the school in question. He submits that the same is in terms of the prescriptions made by the Finance Audit and Fund Department, Government of Assam, in the office order dated 2/4/2025. As agreed to by the parties, the petitioner herein shall personally appear before the Inspector of Schools, Kamrup Rural Circle, on Monday, 15/6/2026 at 6 p.m. At 11 p.m. 11 a.m. On such appearance, the Inspector of Schools shall furnish a communication to the petitioner and therein indicate the documents he is required to submit for the purpose of completion of the audit by the Director of Audit Local Fund Assam. The petitioner shall thereafter finds that the documents are not in his possession but in the possession of the school authorities, shall appear before the headmaster, present academic in charge, as well as the president of the school managing committee. Also, the authorities of the school shall thereafter furnish to the petitioner the copies of the documents in their possession and which is requisite for the purpose of submission before the audit by the before the Director of Audit Local Fund, Assam, by the petitioner. The Inspector of Schools shall by Friday ki 9 Friday. By 12 2026 inform the school authorities about the passing of the present order and that the petitioner shall be appearing before the school authorities on 15 and 16 for the purpose of 16, 15, 6, 2026 and 16, 6, 2020 for the purpose of collection of the document. Also, on the collection of the documents, the petitioner shall furnish the same to the Director of Audit, bracket Local Fund, Assam. The Director of Audit on receipt of the complete documents shall complete the shall on receipt of the documents, complete the audit process within a further period of 1 month and submit the audit report to the Inspector of Schools, Kamrup Rural. Basing on the said audit report, the Inspector of Schools shall thereafter prepare the pension proposal of the petition and submit the same before the Director of Pension for disbursement within a further period of 1 month from the date of receipt of the audit report from the Director of Audit, Local Fund. The authorities who have been named in the above, herein above, shall strictly adhere to the timeline set out by this court in the present order. So, Duma hol na? 2 months. Restrict to list this matter again on no, dos. On 17/8/2026, on the next date of listing, the respondent, learned counsel for the respondent shall apprise this court about the developments taking place in the matter. Ms. Mushahari shall download a copy of this order and forward the same to the Inspector of Schools, Kamrup Rural, Amingaon, for necessary compliance.
My lord, my simple one thing should be mentioned, my lord. The bank statement in his possession, so school cannot give. So that line should be.
So, report liquidation for collection of documents which are not available with the Inspector of Schools, Kamrup Rural, Amingaon, being the present DDO of the school in question.
Bank statement is with his possession, so there should be a direction, my lord. Otherwise, he's.
Mr. Purva, don't give me that impression of your client being having some ego. We get that vibe. This whole thing will.
So bank statements.
Whatever is there, he doesn't get come back, file an application, we'll say. He himself said he has collected it.
Yes.
And he's kept it.
But
If you have some ego, he also know how to get it done.
Yes, sir.
We'll get it done. Don't
Yes.
worry.
Your lordship order, they will give.
If you don't keep, come back. Yes. We'll ensure.
Yes. Obligation.
Top of the list asil no JM Chaudhary wahi hai sir. Ito avatal lui das avatal 6 matide.
May I please, your lord? My lord, this is regarding compassionate appointment. Father died in 2010, my lord. And first application was submitted on by his mother, my lord, on 12/12/2010.
Date of death?
Death is, my lord, 24/2/2010.
What was he?
He was working as the junior assistant under establishment of circle officer at Udarban Revenue Circle.
Udarban.
Lordship. Udarban.
Then application submitted?
First application submitted by his mother on page 30 million. On 12/12/2010.
13.
10.
12.
12/2010.
Date 12.
12/12 again 12.
2010. Mother.
Mother.
What was your age at that point of time?
At that time, he was minor, my lord. Minor. Then he submitted his application on 7.
What is your date of birth?
His date of birth is there, my lord, page 30. 7/10/1997.
Date of birth?
7/10/1997.
1997. 18 years would be When did you submit your application?
On 7/1/2019.
You were major in 2015.
Yes.
Your mother submitted your application in 2010. What process, what steps did you take thereafter to
My lord-
process that, pursue that application?
But that was not proceeded.
Okay.
Then writ petition was filed. Page
By the
20
petitioner.
by the petition.
Writ petition number?
Number 5370/2021. During the pendency of the writ petition, my lord, the matter was proceeded at the DLC, and accordingly, writ petition was withdrawn with the liberty to file a representation before the deputy commissioner. My lord.
DLC, what happened?
Then DLC has recommended his case.
When?
My lord, DLC recommended on 5/3/2022.
Where is that recommendation?
Page 30, my lord.
30. What is this page 15?
Page
15?
5015. Yes, 15, my lord. This is one of first my notes.
Okay. Then where is that page?
Then page 30.
Please, you.
Page 30.
Where is your name?
My name.
Mahmood Hassan.
Yes, top, my lord.
Any post.
Everything is there, my lord. My first application, then his application, then date of birth, everything is there.
12/12/2010 is not your application.
No, it's his, that I have stated, my lord, his mother application. At that time, he was minor. So, my lord, then after recommendation by the DLC, my lord, matter was placed before the SLC. SLC by resolution, my lord, dated 22/8/2022, has rejected the case of the petitioner on the ground that page 34, serial number 22, last column, my lord, age at the time of application.
No, that is wrong.
That is wrong. On that, my lord, I am only.
Okay. Now tell me, father's death is of 2010. Right or wrong, some rejection as there, we will set it aside. But why should we pass a fresh direction?
No, my humble prayer is, my lord,
14 years, 16 years.
That is there. My lord, I just refer one judgment of the apex court, my lord. Just
tell me what it is. Name.
My lord, Syed Khadim Hussain. In that case, my lord, what happened?
The mother had applied, then the body had come, then the Supreme Court has. That case has been clarified subsequently to be in the facts of that case. Devabrata Tiwari is more.
Yes. Yes.
So, anything more?
That's my argument, my lord. Let them, my lord, give a fresh call, because the decision on the basis of which my lord, my case was rejected is wrong, my lord.
Okay. Okay. Dismissed. We'll pass the order after I pass that number 1. You need not be here. For your satisfaction, I declared this.
Yes.
Yeah. Oh, how did you? Oh.
Lordship, we can complete the process within 3 months, Your Lordship. But Lordship, the petitioners may approach the liquidator with the relevant documents, and in fact, Your Lordship, here some of.
Shall we dispose it of or keep it pending?
Can you dispose of it?
But Mr.
S. Deca.
Huh?
S. Deca.
S. Deca, learned counsel for the petitioner. Also heard Mr. G. Bordello, learned counsel, appearing for?
Respondent number 2 and 5, Your Lordship.
Respondent number 2. 5. Who is for the liquidator?
Lordship, I am.
2, 5, and 6.
6, Your Lordship.
Also, Mr. R. Borpujari, learned standing counsel, finance department, appears for respondent number 4, while Ms. D. Das Bormont appears for the respondent number 1, 3, 1 and 3. Also, the petitioners in the present petition, by instituting the present petition, has prayed for a direction upon the respondent authorities to pay to the petitioners their voluntary retirement benefits on closure of Nagaon Cooperative Sugar Mill Limited by reckoning the notification dated 15/2/2006 issued by the government of Assam in the Department of Public Enterprises. The petitioners in the present petition have projected that also, as agreed to by the learned counsel for the parties, the present petition was taken up for final consideration and is being disposed of by the same present order. The petitioners in the petition have projected that they were seasonal employees.
Yes.
Seasonal employees in the Nagaon Cooperative. They were engaged as seasonal employees in the Nagaon Cooperative Sugar Mill. It is submitted that during the season, the petitioners were paid their salaries, and during the off-season, they were given a retaining allowance. Also, when was it closed?
In 2010, it was cancelled. Otherwise, it was shut down in 2002.
It is projected that the said mill had continued with its production till the year 2001-2002, and after 2002, for various reasons, the production of the production was stopped in the mill. Also, the petitioners submit that after the stoppage of the after the closure of the said mill, they were without any means of sustenance. The petitioners also contend that many of them live are natives of other states, and accordingly finding the other states, and accordingly on account of closure of the mill and finding it difficult to sustain, the petitioners, such petitioners had moved to their original, to their respective native villages situated in other states. It is also projected that some of the petitioners had left the state of Assam. Some of the petitioners who are residents in the state of Assam had left the state in search of better avenues of employment in other states. Accordingly, they were not in a position to follow up the matter pertaining to release of their voluntary retirement dues. Also, it is projected that similarly situated persons working in the mill have already been released their respective dues by the liquidator, by the respondent number 6. Also, the petitioners further project that being aggrieved by the non-release to them of their respective dues, the petitioners had submitted a representation. You had approached this court earlier?
No, Your Lordship.
Had submitted
2023, they have
6/3/2023 before the Principal Secretary, Government of Assam Corporation Department, praying for settlement of their dues. It is submitted that the settlement of their dues have not occasioned even till the present date. Mr. G. Bodle, learned counsel for the appearing for the learned standing counsel, Corporation Department, appearing for the respondents number
2, 5, and 6.
2, 5, and 6 on instructions have submitted that the processing with regard to finalization of the dues receivable by the petitioners would be completed within a period of 2 months. From 2 months, and thereafter the dues as working out in respect of each of the petitioners would be released to them within a further period of 1 month. He submits that to facilitate an early resolution of the problem, the petitioners are required to submit documents, the necessary documents at their disposal to the liquidator. Also, considering of the Mr.
S. Deca.
S. Deca, learned counsel for the petitioner, has submitted that the propose that the submissions made by Mr. G. Bodolo, Learned Standing Counsel, Corporation Department, is acceptable to the petitioners. So, in view of the concession, in view of the agreement arrived at by and between the parties in the matter, this court directs the liquidator, directs the petitioners to appear before the liquidator within a period of 1 week from today. Okay,
2 weeks, your lordship,
2
because
weeks
they are
from today. The liquidator on the petitioners appearing before him, liquidator on the petitioners appearing before him shall inform the petitioners about the documents requisite to be furnished by them in the matter. The petitioners shall thereafter furnish the said documents within a period of further 2 weeks. So thereafter, the liquidator shall process the matter and finalize the dues receivable by each of the petitioners. On such finalization of the dues receivable by the petitioner, the liquidator shall, within a period of 2 months, after submission of, within a period of 2 months from date of submission of documents, finalize. On completion of the, on finalization of the dues receivable by each of the petitioners, the liquidator shall transfer the amount involved to the petitioners in the account numbers that they would now declare on appearing before the liquidator in terms of the directions passed herein. So, the liquidator is directed to strictly comply with the timelines as provided for herein. The petitioner as well as the liquidator is directed to strictly comply with the timelines as prescribed herein above by this court. So, with the above observations and directions, the present petition stands disposed of.
Pledge.
Yes, Ms. Musai.
Lordship, just now, Lordship, in the minutes of the joint committee was sent to me, your Lordship.
Joint committee.
Lordship.
Give me.
Joint sitting of the
Joint committee,
Sitting
joint
of the
sitting, show me.
Finance Department, your Lordship.
Then we will take care of it. You
Lordship.
give me a copy.
Lordship.
How? What is the
Lo-
joint committee's report? Tell me.
Lordship, it is
There is
stated.
the latest decision of the division bench.
Lordship, yes.
Why did you not say this when the director was here?
Lordship, what is stated in the minutes is that the service of
Where is the DLC minutes? SLC minutes?
Lordship.
Any such observation made in the SLC minutes?
Lordship, in fact, the state level committee had recommended.
No. State committee has deferred the matter to joint committee. Joint committee
Who is
said
this joint committee?
it's not conceived in the act. Joint committee says he has to get a report from independent.
Independent.
Everything is
authority.
coming in my favor and now it's hanging.
Who is this independent authority?
Independent authorities are given to the Lordship to verify on the field level. So it is given to the.
Who gives them?
It is by the government. Yes, your Lordship.
Government gives.
Lordship. I'll have to obtain instructions on that, your Lordship.
You complete your instructions
Lordship.
and tell your director, tell your secretary
Lordship.
that if this is found to be done by this joint committee and you're still harping on that before this court, not only this bench, now the division bench has passed the order, we'll
Lordship.
be very strict on this. Heard Mr. A. Chakraborty, Counsel for the petitioner. Also heard Ms. D. Mushahari, Standing Counsel, Secondary Division Department, and Mr. R.
Yes, sir.
Mushahari, Standing Counsel, Finance Department. Ms. Mushahari submits that although she has received instructions in the matter, the same is not complete and she commits that she be granted a week's time to complete her instructions and apprise this court as to why, as to the exact reason as to why the petitioner, services of the petitioner were not provincialized. Petitioners in the above noted writ petitions were not provincialized. Ms. Mushahari is cautioned that in the event the services of the petitioners are found by this court to have been not provincialized, basing on recommendations made by authorities foreign to the provisions of the Act of 2017, this court would pass appropriate orders as would be deemed fit and proper on the next date of listing. Registry to list this matter again on 21 by no.
10th.
On 18/6/2026 for motion.
Much obliged.
Ms. Mushari, this is not done.
Lordship, yeah, 91, page 91 is very clear, Your Lordship. He was recommended, as recommended by the SSC, this director submitted proposal to the government for
Ms. Mushari
provincialization.
shall place before this court the recommendations made in respect of the petitioners in the above noted writ petition by the jurisdictional DLC, the SLC, as well as the purported joint committee.
No, Lordship.
Lekha. I've heard the Illinois Council for the parties, huh? There was the grievance of the petitioner has been noticed here in above. The petitioner, by way of instituting the present writ petition, has prayed for a direction upon the Director, Higher Education, to expeditiously consider the minutes, the recommendation made by the selection committee of the college in its meeting held on 13/5/2024, selecting the petitioner for recruitment against the post of assistant teacher bracketed Hindi in the college in pursuance to the advertisement dated 6/8/2019. The petitioner, in support of the decision arrived at in her favor by the selection committee, has relied upon the decision of a coordinate bench of this court passed by order dated 21/10/2019 in IA bracketed C number 3348/2019, and the directions passed by the coordinate bench of this court by judgment and order dated 21/11/2023 in WPC number 7667/2019. Also, before this court proceeds to examine the basis of the submissions made, a basis of the claim made by the petitioner in the present writ petition, this court is of the view that the provisions of the office memorandum dated 8/11/2018 being relevant is to be noted. The relevant portion of the said office memorandum relevant, relevant portion of the said office memorandum dated 8/11/2018 is extracted here in below. To me, office memorandum to A2, page 64. A2A, Bishop. So, a perusal of the said office memorandum, more particularly the distribution of marks as mandated therein, would go to reveal that for the purpose of selection against the post of assistant professors / librarians in provincialized colleges of the state, the selection committee is to make the selection in question by apportioning marks in the following manner. A, academic record, 70 marks. B, research contribution and experience, 25 marks. Amongst the various subclassification made under the heading research contribution and experience, comma, in clause 2 bracketed 7, it has been provided that for teaching / library management experience in the concerned subject / domain, the selection committee is to assign 1 mark each, 1 mark for each completed year of service rendered by the candidate, comma, after acquiring UGC norms in a provincialized / government / affiliated degree college / libraries of government institutes. The said prescription is, however, stipulated with the further, the said prescription is made with the further stipulation that for the experience, for the teaching experience, maximum of 3 marks can be awarded. Also, the said prescription accordingly puts a cap on the marks that can be granted by a selection committee for the teaching experience component of the research contribution and experience segment of the distribution of marks. Also, having noticed the provisions of the office memorandum dated 8/11/2018, this court would now consider the submissions made by the learned counsel for the petitioner with regard to the basis of the decision of the selection committee, which is sought to be implemented by way of institution of the present writ petition. The petitioner has based the petitioner has contended that the decision of the selection committee to be based on the directions passed by this court by order dated 21/10/2019 in I number 3348/2019 and WPC number 7667/2000 and by judgment and order dated 21/11/2023 in WPC number 7667/2019. This court would at the outset consider the order dated 21/10/2019 passed by the coordinate bench in IA number 3348/2019. The relevant portion of the said order is extracted. The relevant portion of the order is extracted herein below for ready reference. Para 235 or para 5. Page 32 of 2 pra. Page 36, 35, sorry, 35 para 2 pra 36 para 5. Also, yate. To me word, Baba. take into consideration para 5. Take into consideration. Itu underline kori diba, bold kori under tolot likhiba emphasis added bracket added by this court. Emphasis added. So this court has perused the said order dated 21/10/2019 and finds that the petitioner, on apprising the court that the selection for the post in question was already held on the date when the said hearing was being taken up by this court, that is on 21/10/2019 at 9:30 a.m. This court opined that it was not certain as to whether the authorities had taken into consideration the experience of 15 years rendered. It was further. It was further. The learned counsel for the petitioner is found to have raised an apprehension that it was not certain as to whether the authorities have taken into consideration the experience of long 15 years of service rendered by the petitioner in the college. Also, thereafter, noticing the submissions made by the learned counsel, standing counsel, secondary education department. Hey, at a secondary education, this court, the coordinate bench of this court proceeded to pass a direction requiring the respondent authorities to take into consideration the said long 15 years of experience in service gathered by the applicant at the time of selection for the post of assistant professor in Hindi in the aforesaid Mahavidyalaya. From the order dated 21/10/2019, this court does not find that the coordinate bench, while passing the said order, was apprised about the existence of the office memorandum dated 8/11/2018 governing the selection, governing the procedure for selection against the post of assistant professors in provincialized schools, colleges of the state. But the coordinate bench in the said order is also not found to have directed for consideration of the teaching experience gathered by the petitioner because the provisions of the guidelines as notified by the order dated 8/11/2018. Also, having examined the said order dated 21/10/2019 passed by the coordinate bench in I bracketed C number 3348/2019, this court would now examine the order date, judgment and order dated 21/11, shall now consider the judgment and order dated 21/11/2023 passed by the coordinate bench of this court in WPC number 7667/2019. Also, the relevant portion of the said order is extracted here in below for ready reference. Para 2 para. Para 9. B to B mariation. A perusal of the said order would bring to the forefront that the coordinate bench had at the outset rejected the challenge presented by the petitioner in the said writ petition to the advertisement dated 6/8/2019. So thereafter, the coordinate bench noticing the order dated 21/10/2019 passed in IA bracketed C number 3348/2019 had further considered the submissions made by the college authorities that the impugned that the order said order dated 21/10/2019 having been received after the completion of the selection process, the consideration as mandated therein could not be given to the petition. Having noticed the said contention, the coordinate bench of this court, while the order dated 21/11/2023 held that the reasoning as advanced by the college authorities to be not a fair one. It was further highlighted that although it was further held that there being a direction from the court to take note and give it was further held that in spite of taking note of the factual circumstances, there still was a direction from this court to take note and give due consideration to the 15 years of experience of the petitioner in the selection process. Accordingly, it was held that the receipt of the certified copy of the order after the date of interview could not have been a reason for the college authorities not to follow the direction of the court or not to give due consideration to the 15 years of experience of the petitioner. Accordingly, the coordinate bench disposed of the writ petition by remanding the matter back to the selection committee with a direction to comply with the remanded back the matter to the selection committee to comply with the directions passed while order dated 21/10/2019 in IA bracketed C number 3348/2019, and upon taking due note of the 15 years of experience of the petitioner, to give adequate weightage in the selection process and thereafter to bring the selection process to its logical conclusion. On a perusal of the order dated 21/12/2023, this court finds that the coordinate bench had only directed the selection committee to take into account the 15 years of experience of the petitioner and to give adequate weightage thereof in the selection process. This court had not interfered with the provisions pertaining to grant of marks for teaching experience as contained in the office memorandum dated 8/11/2018. This court had not further directed the selection committee that the selection committee was not duty bound to follow the prescription made in the office memorandum dated 8/11/2018, and it was permissible for it to devise its own methodology for rendering justice to the petitioner. In short, this court finds that the only direction was to the selection committee to consider, to take note of the 15 years of experience of the petitioner. and to give adequate weightage as was directed by this court, by the coordinate bench of this court, while order dated 21-10-1990. 2019 in IAC number 3348/2019. So, in view of the above discussion, this court finds that the directions passed by the coordinate benches in IAC numbers and WPC numbers so and so was only to the extent of directing consideration of the teaching experience gathered by the petitioner in the college and had not directed that such consideration is to be extended to the petitioner in violation of the guidelines governing this selection. This court finds that the coordinate benches were aware of the fact that it was not permissible for it to pass any direction which would be in violation of the guidelines as mandatory guidelines as set out, as notified by the as implemented by the office memorandum dated 8/11/2018. Accordingly, and it is for this, and it is on the basis of, and it is for the said reason that the coordinate benches had not made any further direction pertaining to the office memorandum dated 8/11/2018, more so when it was not under challenge. So, having understood the purport of the directions passed by the coordinate benches in the proceedings of IAC number so and so and WPC number so and so, this court would now consider the decision of the review of the selection committee in its meeting held on 13/5/2024. As noticed herein above, the governing body, in pursuance to the passing of the order, judgment and order dated 21/11/2023 in WPC number 7667/2019, had taken a decision in its meeting held on 30/4/2024 to reconvene the meeting, to convene a meeting of the selection committee for consideration of the case of the petitioner in terms of the directions passed by this court. So, it is accordingly, the selection committee on being convened had met on 13/5/2024. The minutes of the selection committee being relevant to the issue arising in the present petition, the same is extracted here in below. Page 50, C to C. So, as noticed herein above, this court in the earlier round of litigation instituted by the petitioner, having only required the selection committee to consider the 15 years of teaching experience gathered by the petitioner in the college at the time of her selection, the selection committee was required to evaluate the teaching experience processed by the petitioner and then mathematically apply the marks as provided for teaching experience in the office memorandum dated 8/11/2018. Also, a perusal of the minutes of the selection committee as extracted herein above would reveal that by projecting the orders of this court, as well as the institution of a contempt case by the petitioner, it is noticed that a decision was arrived at to award weightage to the petitioner in experience marks 15 in place of 3. The selection committee had also stipulated that earlier petitioner was given 3 marks as per UGC and DHC's guidelines. A perusal of the said operative portion of the minutes of the selection committee meeting would go to reveal that it had provided 15 marks. It had awarded 15 marks to the petitioner in terms of the directions passed by this court in WPC number 7667/2019. As already noticed, there was no such direction passed by this court. Accordingly, the selection committee, which is a creation, which is created under the provisions of the office memorandum dated 8/11/2018, could not have acted in excess thereof. The selection committee is found to have acted in the matter in awarding 15 marks to the petitioner for teaching experience beyond exceeding the jurisdiction vested in it. There being a cap for teaching experience set out in the office memorandum dated 8/11/2018, the selection committee could not have exceeded the same on its own violation without there being an express direction to the said effect from this court. Also, this court, while passing this court in the judgment and order dated 21/11/2023, having not in any manner dealt with the prescriptions made in the office memorandum dated 8/11/2018, the marking pattern as set out therein, including the award of marks for teaching experience, continued to hold the field, and it was not permissible for the selection committee to breach the same. This court finds that the selection committee in the matter went beyond what was directed by this court. Accordingly, this court is of the considered view that the selection committee, by misdirecting itself in law, by confusing a direction of this court for consideration of the experience of the petitioner to be a mandate for award of 15 marks, proceeded to review its earlier decision and select the petitioner herein. The selection of the petitioner accordingly is on account of a result, is the result of a mathematical distortion made in the matter by the petitioner, by the selection committee, which would also have the effect of violating the rights of other candidates. who were in the fray. Also, accordingly, this court finds that the action of the selection committee to be not in connoissance with the guidelines under which it was so created. And accordingly, the decision of the selection committee arrived at, and accordingly, the decision arrived at by the selection committee in its meeting held on 13/5/2024 would mandate an interference from this court. Accordingly, the said decision of the selection committee stands set aside. Consequently, the decision of the governing body arrived at in its meeting held on 13/5/2024, accepting the recommendations of the selection committee, also stands set aside. Also, having interfered with the selection committee's minutes dated 13/5/2024, the basis of claim made by the petitioner in the present petition stands removed. Accordingly, the petitioner cannot claim for being now considered for appointment against the post of Hindi Assistant Professor Hindi as advertised by the advertisement dated 6/8/2019. The materials brought on record reveal that the selection committee in the first instance had selected one Pooja Borua for the said selection against the said post. However, the said selection having occasion in the year 2019, it is stated in the bar that said Pooja Borua had never come up before this court raising a grievance with regard to non-processing her such selection for appointment against the post in question. Considering the long lapse of time occasioning in the matter, this court requires the college authorities and the director, higher education, to arrive at a decision with regard to the manner in which the said post would now require to be filled up. In the event a direct recruitment is directed to be, in the event it is decided that the post would be filled up by way of direct recruitment, the petitioner be granted an opportunity to participate in the selection process, provided she fulfills the requisite eligibility criteria and the age of the petitioner is permissible to be so, overage of the petitioner is permissible to be so condoned. Also, at this stage, this court would like to consider the submission made by Mr. B. Chetri, Learned Counsel for the petitioner, that in the event this court takes a view contrary to the one taken in the order dated 21/11/2023 passed by this court, by the coordinate bench of this court in WPC number 7667/2019, the matter would be required to be referred to the larger bench. From the discussion made in herein above, this court has not taken a contrary view than that taken by the coordinate bench. This court has found that this court has, on an examination of the materials coming on record, found that the selection committee, that it was the selection committee which exceeded its jurisdiction in the matter and had, by misinterpreting the directions passed by this court, by the coordinate bench of this court, proceeded to conduct a selection, proceeded to select the petitioner in violation of the guidelines set out in the office memorandum dated 8/11/2018. So accordingly, there being no different view taken in the matter by this court with the view taken by the coordinate bench of this court, the said submission of the petitioner would not learned counsel for the petitioner would not mandate a further consideration. Also, this court has also perused the judgments, has closely perused the judgments relied upon by the learned counsel for the petitioner. On a consideration of the same, in view of the conclusions reached by this court in the attending facts and circumstances of the matter, this court is of the considered view that the same would not advance the case of the petitioner, and accordingly, a detailed discussion on the said decisions is not made in the present order. So, with the above, in view of the above conclusions drawn by this court, in view of the above discussion, the present petition stands disposed of. So, Mr. Chetri, I'll make some corrections. Give me a day or two. You'll get this latest by Monday. You can apply, Monday you will get it.
Yes.
Because it'll take some time to type out and give it to me. Sorry, you tried a lot.
It is up to your lordship's prerogative.
It's not prerogative, sir. Nobody has a prerogative. Nobody has a prerogative. Your prerogative is only to argue. My prerogative is to pass an order.
Yes.
But I cannot pass an order which is illegal. And you can't make an illegal submission. The only thing is, if you had challenged that, and this court had said, oh, at that point, likit was. This court also notices that the total marks in terms of the office memorandum is 100. And it's divided as, and is further subdivided as follows. A, educational profession, research and here. So, in the event the petitioner, in the event the selection committee is, the action of the selection committee in awarding 15 marks to the petitioner is upheld, it would result in the petitioner being considered in the selection process out of 112 marks, while the other candidates were so considered for 100 marks, which is again impermissible.
Yes.
Next stage, next level.
It is the prerogative of my argument, my lord. It is the prerogative of lordship's passing the order. And now the litigants will come, whether you will prefer appeal or not, that is his prerogative.
See, this issue, I tried to find out any instance I've not got. So it's an issue which requires to be tested.
Let us hope for the best. What can be done? Obliged, lordship.
Yeah, Mata. Listen, Mata, I'll keep it high. Do it, Rutaro, I can get even more. This one, Mata. Hey, but Obido. Yes, item
15, Lordship.
My lord, here, my lord, the fixation of pay, my lord.
Here in this matter, what has happened, that a hearing was conducted on 30/5/2026, wherein the principal of that particular college was also called for. Therein, he has, Lordship, shown some documents, Lordship, from where it is, Lordship, may I read the fourth para of that instruction, Lordship? I placed just now, Lordship. May I read, Lordship? During the course of hearing the
Just some.
তোমাৰ তাত এখন ভাল কপি আছে নেকি? এই যে এইখন ডিপিচি খনৰ নামটো কাটি আছে ন ডিপিচি খনত টাইপ কৰি দিছে ৰিপিটিশ্যন আছে তেওঁৱে ৰাখিছে 37 টো চোৱাচোন এটা গোটেই কপিটো নাই ফুল কপিটো তেওঁ কৈছে ন তেওঁ মেম্বাৰ আছিল বুলি এখন তুমি এফিডেভিট ফাইল কৰিছা নেকি মই এফিডেভিটৰ কপিও মোক দিয়া মেম কাটি গৈছে এইখিনি
But Mr. S.K. Medi, learned counsel for the petition. So, but Mr. D. Upamanu, learned standing counsel, higher education department. Mr. Upamanu has placed on record a speaking order issued by the Commissioner and Secretary to the Government of Assam Higher Education Department, wherein it has been noticed that there appears to be some discrepancy with the Departmental Promotion Committee, Constitution of Departmental Promotion Committee and the resolutions adopted by the said committee. There appears to be a variance with regard to the documents pertaining to constitution of the Departmental Promotion Committee and the decision arrived at by it from the documents annexed to the writ petition and the documents available in the records of the college. Accordingly, the Commissioner and Secretary had required the Director of Higher Education Assam to conduct a detailed inquiry into the matter and thereafter to submit a report within 1 month from the date of the speaking order, that is 8/6/2026. In view of the said development taking place in the matter, this court adjourns the hearing today, adjourns the matter today, and directs the registry to list this matter again on 22/7/2026. Mr. D. Upamanu shall, on the next date of listing, invariably bring on record the inquiry report now required to be submitted by the Director of Higher Education in terms of the direction contained in the order dated, speaking order dated 8/6/2026.
Only one thing, my lord, is
A copy of the instructions furnished, a speaking order dated so and so, furnished by Mr. Upamanu is kept on record and X, the purpose of I do.
only I want to, the order is reflected in speaking order, my lord, 30/4/2026. This is lordship, the order, my lord. This order was as agreed by the learned counsel for the parties, raised it to list the matter again on so and so, my lord. This was the order, and in compliance of this order, the speaking order is.
Where did you get that thing?
My lord?
Where did you get that?
On this court order, my lord. 33.
That it is reflected here.
Yes, my lord, the speaking order.
You are given a copy of the speaking order?
Yes, I've been.
Fine, very good.
And my lord, only thing was, my lord, is when he was the head of the department, my lord, the DPC was held at that time, my lord.
You don't want the inquiry to, you want to have the matter today?
No, my lord.
That's why wasting.
Yes.
Lordship, Alpha responded 3 and 4.
Your name?
S.A. Bhatia.
S.A. Bhatia, Learned, S.A. Bhatia.
A. Bhatia.
S.A. Bhatia, Learned Counsel for the respondent number
3 and 4.
3 and 4 is present.
22nd July.
Obliged, Lordship.
You got your pension?
No.
No. Yes, where is Miss Mushari? Yes, what happened? You are appearing for Director of Accounts and Treasury.
Yes.
What happened?
I have only given one instruction I have seen today, my lord.
No. That last day it was said that the proposal was prepared and forwarded to you.
So whether the proposal has to meet, my lord, the.
You will have to tell me. How can I
Yes,
know?
yes.
Yes, what happened?
Lordship, after this, we didn't get any instruction.
You didn't get any
Well,
instruction.
I will get the instructions. Lordship will kindly accommodate me because I came to know only today, my lord. With all fairness, I am submitting, my lord.
On the Mr. R. Bopuzari, Learned Standing Council,
Finance.
Director of Accounts and Treasury, Assam, submits that he be granted time till 19th,
Yes, my lord.
19/6/2026
Yes,
to
yes, my lord.
receive updated instruction as regards the status of processing of the pension proposal received in respect of the petition.
I will bring my instructions on the strength of what has been submitted to her. Kind.
And if it is not there, let me know, let us know. We'll see what can be done.
Because
We have not given you any proposal.
because I will be
There is a
seeking.
possibility.
Yes.
Yeah.
Scan code. Scan code.
Yes.
You have completed your that 21 days course.
Lordship.
What do you call that? Orientation course and
Lordship.
everything completed. When? Before the
Lordship.
date 2021 or 2001 or
2003, your lordship.
3?
Lordship.
Then you will get it after that only.
Lordship.
So you get it by 2004. But
Lord.
now you have been given in 24.
So, and in the second and third case, your
Lordship, in
lordship
the
is
second-
fine. Second and third
No.
case, your lordship. Here, your lordship, in 2018, we became eligible. Our names were forwarded by the DPC. All rest of the persons were granted the benefit. We were not granted. But subsequently in 2024, not with that date, your lordship, from the date of eligibility.
No, they can grant you even required in 2030, but they will have to grant you from the date
Lordship,
you were
that-
eligible.
that is.
Lordship, in 18 and 19, Lordship, this is my instruction, Lordship.
Benefit to the-
And this is not only seniority, there is money also in.
Lordship, that is
Lordship,
what
that
your-
is not been considered
No, that cannot be.
because it
You have not considered it.
was,
You have not considered now. That is the norm. You saying that only seniority will be considered, that cannot be.
Lordship, in item 17, I'm yet to receive instruction, Lordship. So a small accommodation, Lordship, I will file affidavits in all these matters, Lordship.
Okay, 25 matter. Heard Mr. S. Bothakur, Learned Senior Counsel. Also heard Mr. D. Upamanu, Learned Standing Counsel, Higher Education Department. Mr. Upaman submits that he would file an affidavit on behalf of the respondents represented by him invariably and without fail on or before.
Lordship, let this matter come up immediately after
Any
vacation.
date you give me. Mr. Bhattakur can wait in this case.
Lordship, I will.
On or before 26, Lordship,
26th of?
this month. And let it come after vacation, Lordship.
Okay, on or before 26/6/2026. Registry to, on such filing of the affidavit by the respondents, petitioner is at liberty to file a rejoinder that on or before 17/7/2026. Registry to list this matter again on 22/7/2026 for admission hearing.
Deeply obliged.
All the three, huh? Mr. If you don't file it.
Yes, Lord.
After this, we'll start imposing.
Obliged.
May I please your lordships? Your lordship, last order 9/3/2026, lordships. 9/3/2026.
Lordship. May it please your lordship?
And then order lordship 13/3/2026. Here is the case, Lordship, your Lordship already set aside.
It was
the-
my order, no.
Yes.
My order. Yes.
Lordship, in terms of this order, Lordship of 9/3/2026, the department is verifying once again the petitioner's matter, Lordship.
Oh.
They are
Oh,
verifying
oh.
it once again.
We set aside the order of
Lordship.
the, and you have again
And
referred
there
back.
subsequently there was a contempt proceeding that was also closed, Lordship.
Be that as it may,
Lordship.
we'll revive it. I'll now open up a
No,
contempt.
no, Lordship. In terms
The-
of,
Considering, I'll
no,
open
no,
up.
Lordship.
That is your
My-
comment, I'll open up.
my humble submission is,
Sorry.
Lordship, in terms of this order
If
of
you
9,
people don't know how to write,
in
leave.
terms of
There'll be
the,
other people who can manage.
Lordship. Therefore, in terms of this order of 9/3/2026, the department is verifying once again, Lordship.
What verification?
They are passing the necessary order, Lordship. Lordship, the only difficulty is the person concerned, the officer concerned is some difficulty because of his father is almost in the deathbed, so he is seeking some time. Lordship may fix the matter after 10 days, Lordship. Some order will be passed, Lordship. I am told telephonically, Lordship. Lordship may fix the matter after 10 days.
This court had fixed the matter today, requiring the learned counsel learned standing counsel, Department of Elementary Education, Assam, to explain as to the manner in which the order dated 19/11/2024 was so passed. This court had found that the said order has been so passed in clear violation of the directions contained in the order dated
18 to the
14/12/2023
14/12.
passed by this court in WPC number
2255.
2255/2022. The conduct of the respondents in the, as demonstrated from the order dated 19/11/2024, makes it a fit case to draw up a contempt proceedings against them in the matter. However, Mr. P.N. Sharma, learned standing counsel, Elementary Education Department, submits that the matter be taken up on
After 10 days. Lordship.
on 22/6/2026, on which date he shall produce the fresh orders passed in the matter by the respondent authorities. It is provided that in the event the same is not, the fresh orders withdrawing the earlier order, the orders withdrawing the earlier order dated 19/9/2024, and fresh orders in terms of the directions passed by this court-wide order dated 14/12/2023 in WPC number 2255/2022 is not brought on record by the next date of listing, this court would consider drawing up of contempt proceedings against the respondents. Also, registered to list this matter again on 22/6/2026.
Obliged.
Lordship, in item number 25, I pray for some accommodation. We will file our affidavit, Lordship.
Okay, on a prayer of Mr. P.N. Sharma, a learned counsel, learned standing counsel, Elementary Education Department, registered to list this matter after the ensuing winter, summer vacations.
Much obliged.
Lordship, 3 times they have missed opportunity, so last opportunity may can be.
There is no such last. They will give.
Obliged.
Your Lordship, we pleased to see your Lordship's order 24th of April. They're supposed to get instruction, Lordship, from the government, Lordship. Perfect.
Yes, who is for the second?
22, I am paying. Lordship. In
Hmm.
this case, Thanuram Sir.
No, where is? Thanuram Krishna.
Thanuram, Lordship, in this case, I have received instruction, Lordship. I may granted 10 days time to file in affidavit.
We had passed this order 3 months back.
Lordship, that instruction I have received.
What is the instruction?
Lordship, that Thanuram Soikia.
Okay, that has been uploaded, upgraded. So
Lordship.
you make a statement that they are not required to register, we'll finish it off. Dorpon,
Lordship.
tell them, they make a statement, we'll record it and finish it off.
No, recently compartmental exam will also finish.
Huh?
The result will be declared. So
Yes, if you're not required
this time
to,
also they will be private.
oh, if you're not required to,
Yes, yes, yes. Lordship.
we'll record that. No, I want your oral. I don't have time to read. You tell me.
Lordship, since these provincialized schools are now upgraded to higher secondary school by the government, the teaching and non-teaching staff of these three schools shall be filled up through direct recruitment process instead of adjustment through any other process. However, till fill up the post through direct
This
recruitment.
is not that, no, we don't want that.
Lordship.
You fill it up however you want. We want whether the student's admission should be through Dorpon or
Yes.
somewhere else.
Further registration of upgraded high school through Dorpon portal for the purpose of admission of student governed as per notification of the Assam School Secondary Board so and so.
So Dorpon,
Dorpon.
if they don't register, how will Dorpon work? Mr. PP Dr. submits that he has received, done a standing council, secondary education department submits that he has received the instructions in the matter. PP Dr. to file the affidavit on behalf of the respondents represented by him on or before 18/6/2026. Registry to list this matter again on 22/6/2026. No further time shall be granted for filing affidavit.
Obliged.
May his lordship, my lord, kindly be after some time, my lord, pass out time.
On the prayer of the learned council for the, you're making this prayer on?
Ke Gugoi, my. Ke Gugoi.
On the prayer is made on behalf of Mr. K. Gugoi for an adjournment in the matter. Also, Mr. S. Sharma, learned counsel for the petitioner is present. Also, accordingly, registry to list this matter again on 23/6/2026.
Obliged.
I'm sorry to interfere. Yeah, I came to the status code. That
Status quo order, interim order passed earlier to continue till the next date.
Obliged.
Lordship, here, Lordship, also I have received instructions. She is not entitled, Lordship. Let me bring in on bio affidavit, Lordship.
Huh?
She is not entitled, Lordship.
Why?
Lordship, she was initially was allowed to against the leave vacancy.
That point is already discussed by
Yes,
the
Lordship.
court. Report of commissioner has been set aside by this court. Now, in the name of verification of record.
Okay, Mr. Sinha.
Yes,
We heard Mr. B. Sinha, learned counsel for the petitioner. Mr. PP Dr. submits that he has received the instructions and would file the affidavit on or before 13/7/2026. Prayer accepted, registry to list this matter again on 22/7/2026. In the meanwhile, the affidavit being filed by the respondents, the petitioner is at liberty to file his rejoinder there.
Obliged.
Two petitioners have acknowledged.
Lordship, 1 week time may be given, Lordship. Now,
On the prayer of Mr. B. Musahari, learned counsel appearing for respond number 4 and 6. 4 and 6. Mr. Mukta will give them first day.
4 and 6, Lordship.
Registry to list this matter again after 4 weeks on a date to be fixed by. Mr. S. Mukta. Mr. I. Bothakur, learned counsel for the learned standing counsel, PhD department is present.
Yeah, affidavit is more necessary, but PHC, my lord.
That
We
is also-
hope in the PHC, my lord.
My lord, I asked my learned.
Likasan, today Mr. B.C. Musahari and Mr. I. Bothakur, learned standing counsel, it BTC Likiba, Musahari, and Mr. I. Bothakur, standing counsel. PHC submits that they be granted 4 weeks time to file their affidavit. Prayer accepted. Huh? Registry to list this matter after 4.
Obliged.
Now, this is squarely covered by latest Supreme Court judgment, my lord.
That's who can do.
Suken to my lord. Obliged, my lord.
We can fix it on 16th.
Only thing, my lord, whether they're treated as state government employees or not, my lord, that I.
Oh, that in
Yeah,
the
that's one
verification.
milestone.
As similar matters have been directed to be listed on 16th. 2026, registered to list this matter again on 16/6. We have directed similar matters.
Obliged. This matter, we have filed our affidavit, my lord.
Oh, great.
Subsequently, my lord, the Honorable Court directed to file additional affidavit,
Oh,
my lord,
again.
being on some record.
Again.
So, my lord, I received the instruction, my lord. So kindly allow me.
Yes, Mr. Das. Let them file.
It was a justice silo order.
Your prayer has not been considered.
Yes, Lord.
Area salaries.
Yes, Lord. My service was regularized from the
But
very date
Mr.
of
S.K. Das, Learned Counsel for
initial
the petition, Mr. B. Talukda submits that the additional affidavit in terms of the direction passed by this court-wide order dated 1/4/2026 would be filed on or before to next week, on or before 19/6/2026. Registered to list this matter again on 22/6. 22 paine board exam. On 13/7/2026.
Obliged.
This matter, my Honorable Court directed to produce the record, my lord, and record received, my lord. So I is some time so that I go to that.
Lord, every time a different counsel appears and they say that they want time to go through the record, well, it's been happening for the last, my lord, few occasions, my lord. It's a suspension matter, my lord. He's under suspension from 3/5/2000. Sorry, my lord. He was put on a suspension 9/8/2024.
Just a moment, sir. 9/8/2024,
my lord.
What are you?
I'm a senior assistant, my lord.
What is the allegation against you?
Allegation is, my lord, that in 1999, some teachers were regularized, 29 teachers.
Oh, you are one of the.
No, no. I was the office assistant there. And
Which district?
It is in the Morigao district. This matter went up to the Supreme Court. The SLP has been dismissed, and these persons are working and they're receiving their salary, the beneficiaries. The allegation
Is it
against
that case wherein the contempt was there?
Yes,
Was,
yes.
You got him very late.
No, in fact, what has happened, Your Lordship, is that the allegations.
Departmental proceeding done.
Yes, show cause was issued on 3/5/2024.
Huh?
Yeah, 3/5/2024. Show cause charge sheet was issued, but with
charge sheet in the criminal case. No,
in the
2/5/35.
3/5/24.
And when was the suspension order passed?
Suspension 9/8/24.
So what is the error?
No, therefore the subsequent extensions.
No need. There is the prescription of that in Ajay Chaudhary.
Yes, ma'am, it's there, ma'am.
Your suspension is post Royal of Departmental Proceedings.
Yes, ma'am. Yes.
3/5 Departmental Proceedings.
Yes, ma'am. Yes, ma'am.
9/8 suspension.
Yes, ma'am. As per the suspension. True, ma'am.
This is in terms whether they have invoked the provisions of section 6(1) or 6(3). Six one C. Where is the order of suspension?
Willard, it's at Willard page 31.
Yeah. Pass क्या बोल रहे हैं? Extension का.
Show me.
Well,
which paragraph of Ajay Chaudhary?
I want medical service.
Well, reason order must be passed below once. Well, of course, well, it says there are 14 melon. The currency of the suspension should not be extended beyond 3 months. If within this period, memorandum of charges is not served, no delinquent.
If the memorandum
If
of
the
charges
has been served, a reason order must be passed.
That is again in context when you are suspended.
Yes.
Charged a reason
Yes,
order.
what I've submitting here, my lord, even there are other grounds also. Well, if you look at the lordship, looks at the charges. Well, whether it's necessary.
We are only in connection with the suspension. Whether this has to be
Well,
interpreted.
the subsequent extensions, lordship will see, madam.
Subsequent, they have done. That
Because
will not
otherwise,
cover
my lord,
that.
lordship is the gravity of the charges now here. What has happened, my
We are
lord?
not going into the gravity.
Because, my lord, under
The only challenge is the suspension order.
yes, well, I've challenged because, my lord, Bimal Mohanty, my lord, in Bimal Mohanty, my lord, the extension of suspension also has to be, my lord, or continuous of suspension, my lord, has to be looked
That
into, my lord.
3 months Singh,
by-
6 months Singh will not come here.
Because, my lord, the lordship will see the gravity of the charges. Here, I'll come to that, my lord. Let me just, lordship, bear with me for some moment, my lord. The allegation is, my lord, that I was a part of the conspiracy.
Oh, that is in the. You are getting 75%.
Yes, I'm getting it. Lordship will see, my lord. Lordship just kindly have.
Is the loss only to 25% or there is something more?
No, nothing, my lord.
Only
What can-
25%.
What can he get, my lord?
Only 25%.
25%. Lordship will see, my lord. He's retiring very soon, my lord. That's one thing. Lordship will see, my lord. The
When
allegation.
you retire?
My lord, 27, my lord. 27, 20, late last part of 27.
Last part.
The lordship will see the charges, my lord.
Okay. Mr. B. Talukda, Learned Counsel for the respondents. Standing Counsel, Elementary Education Department submits that he would file an affidavit in the matter on behalf of the respondents represented by him on or before 15/7/2017, 2006. 26, sorry. Raised to list this matter again on 29/7/2026. In the meanwhile, on the affidavit being filed by the respondents, the petitioner is at liberty to bring on record his rejoinder. The parties to complete their pleadings by the next date of listing. So an endeavor would be made to dispose of the matter on the next date of listing. Stay for something.
Well, that's
because you told me your loss is only 25%, now not more than that.
No, beyond
There
that.
is no problem.
I'll show, my lord, how this suspension is not even necessary, my lord. The charges have been diluted. The investigation says that there is no fraud. That also show, my lord. I've brought to record everything, my lord.
I know I was the man who passed that order in the contempt petition. I have gone through the
My lord.
records also.
No, in fact, thereafter, my lord, after your lordship passed the
Once
order.
the Supreme Court had.
No, in fact, after your lordship has passed the order, the charge sheet that has been filed, my lord, by the police, that says, my lord, there is no fraud at all. No, my lord, forgery at all, nothing.
Then why a charge sheet?
Exactly, my lord. No, charge sheet, now they are trying to say, my lord, these persons have conspired with the person, my lord, who issued this letter, because the officer, they have,
Okay, we'll see.
they've seen his signature, my lord.
We'll see.
I'll show that, my lord.
Affidavits filed, pleading complete.
Yes.
Pleading complete, my
It
lord.
is submitted at the bar that the pleadings in the matter is complete. Accordingly, raised to list this matter on 29/7/2026 for admission hearing.
Deeply apologize.
Yeah, go ahead, read now. Go ahead, read.
It was just led to OPS and new pension scheme. The matter was referred to mediation. Then in mediation,
Which is the order you want?
yes, my lord, along with the report or results. Order dated 6/4/26. I heard the other copy also.
When was your advertisements issued?
Regarding appointment?
No?
Appointment, my lord, I'm not sure, my lord. Advertisement, process, no. In what
You are
case?
relying on the page 51 order. Dilip Kumar Medi.
No, my lord, there are number of, my lord.
You give me a date of appointment. Selection. On the prayer of the learned counsel for the petitioners, the registry to list this matter immediately after the ensuing summer. You get your facts ready. We'll pass it.
Obliged.
Dilip Kumar Medi, I had appeared. None appears. Oh, Mr. Ali is there. Yes, Mr. Sharma, what is your instruction?
Lordship, instruction is awaited. Otherwise, Lordship, here the petitioner is claiming provincialization under 2011 Act. That act is.
Okay, fine. But you take 6 months to receive instructions. This order was passed on 16/12.
Lordship.
Mr. P.N. Sharma commits that he shall complete his instructions in the matter and apprise this court with regard to the claims made by the petitioner in the matter on the next date of listing. Registry to list this matter again on 24/6/2026.
Okay.
And Mr. Sharma, you can't come. Give a letter of authority to somebody who can come. So we can deem that person to be you.
No, Lordship. I will.
Here, your lordship, in 33.
Oh, again.
Lordship, affidavit has been filed. Your lordship.
Again. Are they still in service?
Lordship. No, it's his client is not
So now he is free.
free.
I have retired from service, my lord. Despite my selection, my lord, I was not appointed. My lord,
Okay.
my retired duties
Pleadings are complete.
Complete.
It is submitted that the pleadings in the matter is complete. Registry to list this matter again on 21/7/2026 for admission hearings. An endeavor would be made to dispose of the matter.
Deeply. Lordship, instruction in this case awaited, I may be granted 2 weeks time to get the instruction and file affidavit.
May I please, your lordship, dear lordship, the impugn order is passed for the compliance of the Honorable High Court order dated 8/11/2021 and 11/5/2022. But now they have raised another, they have new allegation they have raises in this.
Okay, let him get his instructions, we'll see.
Lordship.
But Ms. K. Borua, Learned Counsel for the petitions, also heard Mr. P.P. Dutta, Learned Standing Counsel, Elementary Education, Secondary Education. Mr. Dr. submits that he be granted time till 14/7/2026 to complete his instructions and file an affidavit in the matter. Pray accepted. Registry to list this matter again on 15/7/2026. The respondent shall invariably file their affidavit in the matter on or before the next date of.
Plus, my name is M. Sarma. M. Sarma.
I'm sorry.
Yes.
Oh.
May I please, your lordship? Lordship, on the last occasion, respondent were asked to obtain instruction, lordship, regarding the pending disciplinary proceeding, lordship. Lordship, that was, they could not finalize the departmental proceeding, lordship, since 10 years. As a result, lordship, I am suffering, lordship. My increment was withheld.
You have not retired or you have retired?
No, lordship, I'm going to be retired on 30th of October in this year, lordship.
Lordship, we have received the instructions in the matter, Lordship. Some time may be granted. to us,
Lordship, I have submitted a representation, lordship, before the respondent, lordship. Today morning, they have issued one letter to me, lordship. This is the letter, lordship.
Mr. Das, what is the system of withholding 1% of increment?
Lordship,
What is that?
Lordship,
Is there a provision for that?
Lordship, there is an office memorandum, Lordship.
Where
As
for me?
per- Lordship, we have received the instruction, Lordship. That
But
is
this
with us,
matter is
Lordship.
of 2000.
Lordship, 26 only, Lordship.
Lordship, it is
26.
last listed on
Lordship,
March, Lordship. Almost 3 months, Lordship.
For the Lordship, revised pay rules of 2010, Lordship, there are provisions where we can withhold, Lordship, certain amount of increment, Lordship. The petitioner was under suspension, Lordship. A criminal trial was going against him.
No, I can understand that 25% of his salaries, if he is 50%, whatever subsistence allowance got, rest can be withheld. But what is this 1%? I'm not seeing it. That's why I'm asking.
Lordship.
What is this 1%? Any?
1% increment of my basic pay.
No. What is the power? From where have they drawn that power?
Lordship,
Lordship, as per the memorandum, Lordship, the
You have
rate
not
of
filed an
annual
affidavit
increment,
yet?
Lordship, we have not placed the affidavit, Lordship. We have received the instructions as per the revised pay rules, Lordship.
Mr. H. Das, Learned Counsel for the petitioner. Or Learned Standing Counsel, Assam,
Lordship,
APGCL.
If I may, Lordship, I appear on behalf of Mr. Deenat, Lordship.
Mr. H. Das appearing on behalf of Mr. Deenat, Learned Standing Counsel, APGCL, submits that an affidavit on behalf of the respondents represented by him shall be brought on record. When are you retiring?
Lordship, 30th of October in this year, Lordship.
Shall be brought on record invariably on or before 26/6/2025. 26. No further adjournment shall be granted in the matter. Registry to list this matter again on 16/7/2026. Petitioner may, in the meanwhile, file a rejoinder to the affidavit if so filed by the respondents. On the next date of listing, this court would make an endeavor to dispose of the matter.
Lordship, one thing I like to submit, Lordship, one of the similarly situated position, one of my colleague, he already getting all the benefits, Lordship.
You will also
Lordship,
get.
he has retired, Lordship. He is in service, Lordship. The current petitioner is in service.
Oh, you get that office memorandum? Let us see.
Lordship,
Madam,
we'll
you also
please,
try to get that office memorandum. We'll have to see the power, source of power. Then we'll decide.
My lord, this is the second litigation arising out of the first WPC case 702/2018 regarding correction of date of birth. 28 years back, my date of birth was corrected as a tracer in the superintendent office, Sunitpur district. And then, my lord, what happened after 20, at the fag end of my service career, I was to be retired as per the corrected date of birth 2017, my lord, as per date of birth, which was corrected as per affidavit that was accepted by the superintendent engineer. It was duly corrected in service book. Then suddenly, my lord, on by the impugn order, my SLC certificate.
In this case,
my
Lord,
date of
I am
birth
filing
was
my
wrongly
affidavit, so
recorded.
sometime will be given.
But that was corrected, and the authorities asked me to produce the original SLC certificate. But original SLC already I have submitted, my lord, at the initial stage in the 1988, my lord. All the documents. Then again, I have submitted.
When did you join your services, Mr. Sharma? When did you join your services?
I have joined in 1988, 7/1/1988.
7/1/1988. Pass metric on?
Metric, my lord. Sorry, my lord.
Have they held an inquiry?
Yes, Lordship, inquiry was, he has come against the inquiry report, Lordship.
Lordship, my judgment in my favor. The first WBC was after hearing both the parties. Honorable Court has set aside the impugn order along with the another two letters by which they are going to deduct my excess salary. According to them, I had worked more than my service career. And ultimately, my lord, what
Okay,
my lord, at this stage, my lord, just my one provisional pension. 9 years have been elapsed now. Provisional pension may kindly be read.
Ready, Lordship, he has to cooperate, Lordship.
Rule 22, provisional pension. Then they may file affidavit. It will be.
Mr. S. Sharma, Learned Counsel for the petitioner, submits that the petitioner, even by construing the date, you have retired from which date? You were
I'm
made to
retired.
retire from which date?
31/1/2015.
No,
And
actually,
according to the date you say, when will you retire?
31/1/2015, I should have been retired.
Hmm.
But actually, I was working till 8/12/2016. 8/12/2016.
According to you, your date of birth, according to you,
According to me,
when will you retire?
I should be retired on 31/3/2017. 31/3/2017.
The Learner Council for the petitioner submits that even going by the date when which is projected by the petitioner to be his date of birth, the petitioner is found to have already superannuated from his services. However, the petitioner has not been granted a provisional pension till date. Also, Mr. N. Goswami, N. Upadhyay, Learned Standing Council, Irrigation Department submits that the respondent authorities shall release to the petitioner his due provisional pension as per law. So, in view of the above position, the respondents in the Irrigation Department are directed to release to the petitioner a provisional pension with effect from the date he was so made to retire by the respondent authorities. And such pension be continued with till the regular pension of the petitioner is finalized. The provisional pension be authorized to the petitioner in his account within a period of 1 month from today. Registry to this matter again on wonderful episode. 13/7/2026. On which day the Learned Council for the parties shall apprise this court as to whether the provisional pension has been credited in the account of the petition.
Only one thing, Lordship, the petitioner is not cooperating.
What cooperation is required? Tell me.
Lordship, the documents, Lordship.
What document do you want?
It is the account number, Lordship.
What account number? Mr. Sharma, give him your account.
I'll
Lordship.
Not yours.
Sorry, only one limited prayer. I have SL here, expertise inquiry report as a consequential report.
Oh, you want that?
That may kindly be stayed because they are going to, in the event of deducting my 7 lakhs rupees, which already they have paid me.
Let them deduct.
Dropping Mas's case, as per
Oh, they are not going to put you behind bars. They'll only deduct money. We'll refund that to you.
That is also SL. Okay, man.
You get your provisional pension.
Yes,
Leave
everything is
peacefully
there.
for some time, then come
Let
back.
them submit affidavit.
And whatever documents are required, the Learned Council for the petitioner is directed to inform the petitioner to cooperate with the respondent authorities towards a release of his provisional pension.
Lordship, obliged.
In the event any documents are required to be so received from the petitioner, where do you stay, petitioner?
Petitioner is residing at Gauhati.
The same shall be received, shall be intimated to the petitioner by the respondent authorities. Respondent authorities. It will also line to cut it. Pass.
Master.
Please, Lordship. Lordship, pursuant to order dated 8/5/2026, we have taken the steps and we have provided the extra copies to the respondent. So may I kindly beg for the matter to be taken up anytime next week, please?
On the prayer of the Learned Council for the petition, registry to list this matter immediately after the ensuing summer vacations. Department proceeding can wait.
If you oblige to Lordship.
So allow me to file my affidavit in this case.
Simple, though I have been promoted to the post of assistant executive engineer, I am not allowed to hold this charge. And here, on 10/4/23, the election committee recommend my name. 4/5/23, my promotion order has been passed, And before joining, I have been arrested.
Mr. N. Upadhyay, Learned Counsel for the petitioner is granted time till 14/7/2026 to file an affidavit in.
Lords.
The petitioner may thereafter file his rejoinder on or before 24/7/2026. Registry to list this matter again on 27/7/2026.
Obliged, my lord. Obliged.
So your matter has reached,
Yes, finally.
but no disposal to them. Enough, I had enough.
So Lordship
But late,
fixed
late
it
May
after
submission will be
vacation.
recorded as a
Lordship.
part hard.
After vacation, if fixed it may
As
take it
agreed to by the Learned Counsel for the parties, give me a date as per your convenience.
I
You're a
was,
busy person, so.
I'd rather prefer before vacation any date, the
No,
last
not-
week.
If it can be here on 23rd, it is a hearing day, or 16.
Subject to madam's convenience.
23rd.
14, 14, 15, 14, 15.
16.
16. For final disposal.
Registry to list this matter again on 16/7/2026, and endeavor would be made. Say to Ahmed. You will remind me.
Sure, definitely. Deeply obliged.
Yes, Mr. Lordship.
Yes, Mr. Ahmed. Yes, Mr. Talukdar, what
My
is
lord,
it?
I pray one day time, my lord, because today I have not received the instruction, but the instruction prepared, my lord, due to some, so.
That matter, yes.
My lord, there's.
Yes, what happened?
Kindly accommodate for that day, my lord, on Friday, my lord. I will put.
Wait, what happened?
What happened, my lord? Actually, the instruction they have prepared, my lord, but due to my lord, the signing authority director, my lord, today there's a personal appearance, my lord, in.
This is elementary.
My lord.
Friday, as prayed for by Mr. B. Talukdar, a last chance is granted for production of the instructions in response to the query raised by this court by the order dated 8/6/2026 in the above noted petitions. This way.
Public. Obliged.
May please, Lordship. Lordship, in this case, as per the last order, Lordship had sought for certain instructions.
How pension was fixed? How pension was fixed?
In the WPC, Lordship, in the writ petition. Sağ ol, bakın sen. Ona WhatsApp'a diyelim.
Mr. Doctor.
My lord.
Just go through these instructions.
Fine.
Give him a copy.
Lordship, I've given him
We'll take it up on Monday. Monday, Parine? Tuesday? Pari. 19th. On 19th.
Lordship.
As agreed to by the Learned Counsel for the parties, registry to list this matter again on 19th. Instructions received furnished by Mr. N. R. Sharma is kept on record and marked as X for the purpose of identification.
In this matter, I am appearing on behalf of Mr. SMT System, my lord. In the last occasion, as told that he has submitted the instruction, my lord, and Honorable Court directed to respondent number 1 for further section, my lord. The pension proposal has been sent to the Assam University, my lord, as per.
Where is Mr. Kail?
May I please, your lordship?
Yes, what happened?
Lordship, the higher education was supposed to give us the calculated amount as per which we would be giving the petitioner the amount, but as of yet, we have not received that. Lordship.
Yes,
That
who is
the
appearing for
instruction.
the higher education? Respondent number?
SMT 60 was appearing.
SMT 60. Yes, what happened?
He has left for due to some personal difficulties, my lord, and he said that
On the prayer of Mr. Prayer is made on behalf of Mr. SMT 60 Learned Council appearing for the respondent number 4 for an adjournment in the matter on the ground that he had to leave the court due to some personal inconvenience. So accordingly, registry to list this matter again on a last stock of Tata that date. 22. That's it. He's having problem. It's it. But next time I don't get something, we are going to do something harsh.
May I please, your lordship? The matter has been sent to mediation, but mediation failed.
Okay, as agreed to by the Learned Council for the parties, registry to list this matter again on 29/7/2026.
Wait, your lordship. Lordship, kindly peruse the orders from my lord 24/11/2025 onwards, my lord.
Yes, what has happened, Mr.? The appeal has been dismissed.
Appeal has been dismissed,
Then,
my lord.
then why the compliance is not
Yes,
coming
my
through?
lord. Now, my lord, the department is taking up the matter to the apex court, my lord. I have the instructions, if lordship may be pleased to.
Apex court has already decided.
Already decided, but my lord, lordship may be pleased to go through.
Will not.
Until and unless, my lord, there is a stay, my lord, they cannot sit over
This
the
order is of 23. You are sleeping.
No, after a long time, my lord.
After a long time, you came to the division bench.
Yes.
That will not give you a fresh lease of life. It's dismissed.
Dismissed.
You do whatever you want to do. But why the orders are not being complied? Who is the authority to comply the order?
Here, my lord, now it is pending, well, lastly, my lord, it was pending before the finance. So we have to give the approval, my lord. So
You have
far,
not given.
That's number 7.
in the meantime, my lord, the appeal was filed and the appeal, my lord, delay condonation petition was dismissed. There was a delay of 844 days.
Gone.
It's gone. Now, my lord, the department has made a communication, my lord, that I have placed before, my lord. That
is between you and the department.
No,
This is not for.
No, therefore.
The court wants that the relief is your appeal that has gone. So this order, why is it not being?
So therefore, my lord, at this stage, if I may respectfully submit, my lord, with all respect and humility, if lordship accommodates me for some time, at least 3 to 4 weeks, my lord, if I do not get any relief from the apex court, my lord, lordship, then the consequences will follow. Consequences will follow. We cannot escape. We cannot escape. That is the only last resort we have, my lord. If lordship takes a magnanimous view of the matter, only to that
When were
extent.
your initial appointments after 2000?
After 1.93, my lord.
Because on merits, my lord.
Declaration, my lord, I was directed to pay the, my lord, minimum scale of pay.
Even, my lord, under the.
But Upendas is no longer existing.
That payment of minimum scale of pay, that was not adjudication of this honorable court, my lord. That was undertaking by the government to pay the minimum scale of pay.
Once the judgment goes, the undertaking goes.
Yes.
Everything goes.
Even if Malad Pindas is not there, Malad, Jagjit Singh Malad will cover my case.
For that, we'll have to reconsider the matter. How can we pass this order? Where is the violation of this?
Unless this order is Malad
notified. As prayed for by the Mr. R. Bapujari,
earlier also
a last chance is granted to take a decision with to comply with the directions passed by the white order dated.
My lord, that is order dated
5/10/2023,
my lord.
PC number 713/2021. So, registry to list this matter again on 31/7/2026, on which date a compliance order shall be placed on record by the respondents.
I am so deeply obliged.
Or we will drop contempt proceedings. Beyond that, what can we do?
My lord, earlier, my lord, while this contempt petition was pending, time and again respondents took time, my lord, on the plea of compliance of the order. In the meantime, my lord, they preferred the appeal. Even after filing the appeal, my lord,
it was
That
submitted
is
before this
because
court.
advice was given.
It was submitted before the court that they are complying with the order. I don't know why
Because
this
now,
thing
my lord,
that going.
post Upenda's death notification.
It's already late.
My lord,
Reserve your
I'm-
energies for
I'm-
night reading of files. Don't spend it.
My lord.
I'm so grateful.
Yes, Mr. Nath.
Regarding this matter, my lord, new incumbent was impleted, my lord, by order dated 5/3/25. So, my lord, 7 days time.
You have
is
not
granted.
given an amended cost title.
Yes, my lord, it is ready, my lord, I will file tomorrow.
Mr. S. Nath, counsel for the petitioner submits that amended cost. You have taken steps for service of notice.
Notice earlier taken, again I have to take, my lord.
Okay, first you file, submits that he would file the amended cost title within a week from today. Registry to list this matter immediately after the ensuing winter summer vacation.
Obliged.
May I please, your lordship? You have filed the reasoned affidavit in regard to the affidavit filed by the respondent number.
You have filed your affidavit, madam.
Yes, lordship, I have filed it. Lordship, merely two allegations are leveled against me, lordship, and
Just give me 2 minutes.
yes, lordship.
Where is the order of the criminal court? Criminal proceeding?
Lordship. PRC 1267 oblique 18. Annexer F is 33, lordship.
Fourteen to 2019. Criminal.
Yes, your lordship.
Then where is the show cause notice?
Two so cause notice was given to him, lordship, and
Where is the show cause notice, madam?
lordship, one second. It's annexer B, lordship.
B.
Yes, 24.
Page 24.
Yes, lordship.
No, that is not, page 31.
Yes, lordship. Sorry.
What is the date of this? 18. Enquiry report is on record. Okay, enquiry report is. The victim girl was examined, statement of Pallavi Bora. This is of date. When is the enquiry report dated, Mr. Findings? Just Yes, Mr. Soikia.
My lord.
The
That,
statement of the lady,
my lord. The victim.
but during the trial, that's why I wanted the date of this, on which date this statement was recorded. Do you have that date, madam? Page 40, you will find the statement of P.
Yes,
Purvi
yes.
Muzumdar. When was that statement recorded? You have the records with you?
The report is not available with me, my lord, but one affidavit.
Get
is
the
filed.
records. Because
My lord.
in the criminal proceeding, which was disposed of in 2019,
My lord.
she said there is a misunderstanding.
My lord.
I want to see what exact words she used in the inquiry.
My lord.
Not a case for prima facie. It's not a case for this punishment.
It's proportionate, your lordship.
I'll produce the record.
Let him get the records.
My
We'll have to be sure because the allegation is serious. Of this.
lord.
Lordship kindly has ordered.
Not sure. I'm sorry. It will be after vacations. Your name?
And Sinha.
N. Singha.
Sinha.
Ms. N. Singha, learned counsel for the petition. Also heard Mr. P. Soikia, learned government advocate, appearing for the respondents. Mr. P. Soikia submits that he would produce the records of the disciplinary proceeding imputed against the petitioner in original on the next date of listing. Accordingly, registry to list this matter at a holiday date on 2027. Item number kimana sir tu?
This is 49.
2026. 27.
Highly appreciated.
Obvious.
You get the records, don't miss out.
My-
And the
my lord.
statements of the witnesses,
My lord.
Sir,
All
yeah.
the record, my lord.
just mark it.
My lord. Obvious.
Yes, ma'am. I wasn't-
May it please, your lordship.
Hmm.
Lordship, as per the complaints order, lordship, I was accommodated as assistant teacher, lordship, after my retirement, lordship. Therefore, the
No
finding is not-
retrospective effect given.
No, lordship, I was already retired before accommodation, lordship. But finding is they've wrongly verified.
Yes.
Lordship, I have received the instruction, Lordship. In fact, the petitioner appeared before that screening committee and his name find place in list 1. Was eligible
When
for.
did you retire?
30/06/2020, lordship.
Okay, we'll consider. As agreed to by the learned counsel for the parties, registry will consider. Registry to list this matter again after the ensuing summer vacations. Date to be fixed. Next time comes with.
Let's go.
Mr. Bachaji, Mr. Chaudhary. Sorry, it not be possible today. We'll fix a date for that.
Yes. May I appeal, lordship? Item number 51, my lord, contempt petition, my lord, against the order dated 22/4/2024, my lord. Kindly see order dated 28/1/2026, my lord.
Twenty-eight one.
28/1/2026, my lord. My lord has passed the order for compliance.
Yes, where is the compliance? Who is there?
Mr. S.S. Roy is there, my lord. Contempt. Then after on 23, they again took time. Then on 27, they again took time, my lord.
None appears for the petition, for the respondent. Mr. Kumar, V. Kumar
My lord.
is present for the, heard Mr. V. Kumar, learned counsel for the petitioner. None appears for the respondents. This court had, while order dated 28/1/2026, required the respondents to place the compliance report in the matter. No compliance report is found to be furnished to the petition, brought on record. No compliance report is brought on record till date. Also, however, for the ends of justice, a further opportunity is given to the respondents to place on record the compliance report. Accordingly, registry to list this matter last of October on so and so. Mr. Kumar to inform Mr. S.S. Roy about the passing of the order passed today.
Deeply, Your Lordship.
Heard Mr. A.R. Medi, learned counsel for the petition. Also heard Mr. R. Sharma, learned senior counsel, assisted by Ms. N.B. Kaistock, learned counsel, appearing for the respondents number 2, 3, and 4. Also, it is seen that the fresh steps were taken for service of notice upon the respondent number. Steps were taken, notices were issued to the respondent number 9 on 19/1/2026, on 22/1/2026. However, the service report is found not. However, the AD card, neither AD card nor unserved notice has been received back. So, in view of the above, petitioner is directed to take fresh steps for service of notice upon the respondent number 9 by way of registered post steps within a week from today. Registry to list this matter again after 4 weeks.
Lordship.
Complied.
Complied. Order has been, speaking order has been passed, Lordship.
Where is the direction? You have got an order.
Page
Copy.
number 15, Lordship.
You have got a copy.
No, Lordship.
Mr. P.N. Sharma, learned counsel, appearing for the respondents, has placed on record an order dated 25/2026, passed by the Commissioner and Secretary to the Government of Assam, Department of School Education, in compliance with the directions passed by this court-wide order dated 19/2/2024 in WPC number 6187/2023. A copy of the said order be furnished out to the learned counsel for the petitioner. Registry to list this matter immediately after the ensuing vacations. Copy of the order dated 25/2026 205, produced by Mr. P.N. Sharma, is kept on record and marked as X for the purpose of identification. You will go through it.
Yes, Lordship.
Ramsey, we'll have it after vacation.
Pleasure. May it please, Your Lordship.
Lordship, judgment of 2024. The top of my address will to be issued to the petitioners.
My lord, on the last 29th May, my lord, the verification of documents has been completed, my lord. Now, in very short time, they will be appointed, my lord. That was informed today, my lord.
Short time, Lordship, from 24/26.
My lord, that reason, my lord, I have already filed my affidavit, my lord. Why it was delayed, my lord? Because APSC recommendation was not there when passed the order, my lord. Thereafter, subsequently, APSC has been recommended, my lord, their names. Thereafter, we have process, my lord.
Mr. S. Doctor, learned counsel for the respondents has submitted that the verification of the documents and other credentials of the petitioners have been completed, and their appointment orders would be issued shortly. He submits that the matter be taken up on 15/7/2026, by which date he shall furnish the compliance report. Also, accordingly, registry to list this matter again on 15/7/2026. Ms. P. Sharma, Learned Counsel for the petition,
Respond.
is present for respond number 1.
Obliged, Your Lordship. Highly obliged.
May it please your lordship. Lordship, may kindly adjourn this matter for the day.
On the, yes, Mr. Anything urgency?
Lordship, DCRG was issued in the name of the son of the employee, but the daughter-in-law is not included in the Rule 136. That's the difficulty. So we ask her to get the succession certificate. Before that could be in case he died. The son died.
Okay, she has some problem. A
Lordship,
prayer
may
is made on
fix a
behalf
short
of the,
date. Lordship, may kindly fix a short date, Lordship. 3:30, please.
prayer is made on behalf of Mr. What is his name? F. Khan, Learned Counsel for the petitioner for adjournment in the matter on account of personal. Restrict to list this matter again on Pular piece of paper. 21/7/22. Yes, madam. Seen the Laojima Court order dated 3/6/2026, which reveals that which reflects that service of notice upon the respondent number 3 is held to be, respondent number 4 is held to be completed. So, affidavits filed?
No, Lordship, affidavit we have not filed, but I think affidavit is not required, Lordship, because this is regarding the change of date of birth certificate.
Yeah, but
No, this is different, Lordship. They have annexed to birth certificate.
Now praying for respondent number 4 to change their birth certificate. The school. Lordship, can you prepare?
Yes, Your Lordship. And the birth certificate, one birth certificate, relying on the birth certificate, which they have obtained in 2007, Lordship, they have given it to the school. And school has recorded the date of birth relying on that birth
Show me the date of birth certificates.
Page number 19 and 20.
19 and 20. Two birth certificates.
Different date. Two different places.
Two different places, two different.
19 and
20. Oh, no. Oh, 19. Oh.
19 was the genuine one, Your Lordship.
How can we know which one is genuine, Lordship? There's a disputed question of fact. The first birth certificate
okay.
is 19. It was
In 19, the date of birth is
It's
1st November 2005.
It is my correct.
And in the second one, it is 1/11/2007. Take us. Let us take it as 2005. But you registered it in 2008.
8.
After
Date
3
of-
years. Where is the relaxation or the condonation from the district magistrate?
Lordship, otherwise, before going to anything, Your Lordship, my honest submission is that, yes, that the earlier one, that is page number 19, is a genuine one, Your Lordship. And
What is this?
yes, Your
20?
Lordship, I'm coming to that, Your Lordship. At the time of admission of the son of the petitioner, Your Lordship, his age was 5 years, Your Lordship. And the rest of the students are 2 years younger than him. 2 years and 1.5 years younger than him. And he faced lots of bully, Your Lordship, for that reason, saying that Buddha in this way, Your Lordship.
Okay, before
So
that, you tell me, what does the father do?
he's a lecturer in college, Your
Lecturer.
Lordship.
And then he is resorting to this work.
Otherwise,
He is resorting to
getting
this
any-
work. Huh?
getting any
Lecturer,
options, Lord.
trying to destroy his son's life. And you admit that this is a forged one.
Lordship.
Not the document maybe, but the particulars.
Particulars, Your Lordship.
Huh?
Lordship. We have filed an RTI also before this Kodabari that is not found, Your Lordship, in their register, Your Lordship. The second one, Your Lordship.
So what steps should be taken?
Lordship, now,
Where is he a lecturer working where?
which college I forgot, Your Lordship.
We'll ask the higher education department to take action against him for bringing forged documents, admittedly forged
The
documents.
situation, Your Lordship, I have created all these things in my petition, Your Lordship. why your lordship, they have to take the steps, your
This is
lordship.
not the way, madam, you do it.
That
This is
my-
not the way.
That is my honest
Anyway.
condition, otherwise, your lordship.
As agreed to by the Learned Council for the parties, registry to list this matter last week, no, not dear. No, 7 July. 37/2026 for 37/2026. The respondent shall, if so advised, file their affidavits in the meanwhile. Not doing anything, enjoy your vacations, come back. We'll see. Don't pursue with this, ask them to withdraw, take up some other step. And you consider the young boy, father did something, why should he suffer? You go by the earlier one, means page 90.
That was obtained later on, lordship.
With that as it may,
Later on.
2008, do it. Let that boy's life not be.
Always we are considering
Because if they
everybody's case.
insist, if you say that there is problem, then we'll have to proceed against the father. Otherwise, it will not come to a logical conclusion.
They have read now, lordship, they are filing this case now. But 2005, 25. That he has passed examination in the year.
My only thing is that father being a
2010.
lecturer should not have done that. That's the only sad part of it. But a young boy's life will not let it go like that. We'll do something. We'll do something, don't worry.
Obliged.
Please, Your Lordship. Lordship, this application is filed praying for amendment of the writ petition, Your Lordship, with regard to the impugned order that has been placed before the court, Your Lordship. And I have also prayed for impleading respondent, principal secretary as the respondent.
Tomorrow. We'll take up the main writ petition itself.
Lordship, can it be next week then?
No, tomorrow.
Tomorrow, Your Lordship, I won't be available.
Then you argue today.
Yes, Your
Main
Lordship.
writ petition.
Yes, Your Lordship.
Forget this collection and all. Come to the main writ petition.
Your Lordship, actually, Your Lordship.
When is the date of birth? Date of death?
Your Lordship is.
2010.
Harness.
2010, Your Lordship, there is a mandamus in my favor.
To me.
Yes, Your Lordship. Your Lordship will find that. Lordship,
Oh, there was a recommendation in your favor by SLC.
yes, Your Lordship.
Yes, why didn't you not appoint? Where is the recommendation, show me?
Your Lordship, thereafter, Your Lordship will.
Where is the recommendation of the SLC?
Your Lordship, it's mentioned in the order of 4998 of 20.
Oh, you have not brought it on record.
I have brought it in, Your Lordship, actually what happened when the writ petition was going on, they have placed it on record that SLC has recommended me.
That is earlier. Writ
Yes, Your Lordship. Then
after that,
the Honorable High Court has directed to appoint me in a grade 4 post, Your Lordship.
yes, Mr. Why he has been appointed? You have recommended his name. Why he is not appointed?
And Your
Lordship,
Lordship,
may I kindly see the additional affidavit filed by the interlocutory application, Lordship. The SLC, my notes of the meeting has been, my Lord, annex, Lordship, annex of 5.
Where? Page?
10, Lordship, annex of 5.
Where is the name of the petitioner?
In the, my Lord, the first page, last number.
Abdul Mannan. Which name? Abdul Mannan. It's recommended.
Your Lordship,
Earlier it was recommended, then my Lord, it was left, my Lord, my Lord, why it was left, my Lord, that.
Why?
after
What
that-
lapsing? There is no lapsing.
After that, my Lordship, may I kindly see the last. page, Lordship.
Last?
Annex, page 13, Lord.
Yes. Yes, what is here?
Lordship, I am sorry, Lordship, annex, page 12, Lordship, last paragraph, Lordship. The committee who took note of the OM dated so and so issued by the personnel department, whereas it was directed no case of the no case for appointment and compensatory ground, the family members
of the state government employees who died
Okay.
harnessed in retired.
As agreed to by the Learner Council for the parties, raised it to list this matter again. Last week of July.
Your Lordship, in the earlier occasion, Your Lordship, this court has by its order has suggested Your Lordship to file an appropriate application because that.
We'll consider everything together. Due to paucity of time, positive.
Thank you.